the matter on 16, when your lordship was pleased to grant me leave to file the appeal without the certified copy. But the main advance for your lordship is, my lord, my client is a contractor who obtained a contract on 2022 for providing housekeeping and cleaning service to respond number 3 with the North Bengal Medical Hospital and hospital. Now, my lord, my contract is for 3 years. And in the contract, my lord, it has been stated, my lord, it is renewable for 1 year, subject to satisfactory performance. For the last 2 years, there is no blemish on my part. Suddenly, my lord, they have issued a contract, tender that is to be opened on 17th, and the 19th is the date. And your lordship was pleased to direct me to file the appeal. And now, my lord, I should be candid to your lordship, my lord, it has been extended till 24th. Therefore, my lord, I was humbly praying, kindly give me some priority in this matter. Otherwise, my lord, your lordship knows if against the interim order refusal, my lord, the single judge has directed to extend the evidence. The interim order was not passed. And your lord, my lord, this is a civil consequence, my lord. This is if something happens, it cannot be compensated by means of by damages. Therefore, my lord, I was humbly praying, my lord, kindly fixes the matter tomorrow, my lord. Tomorrow, your lordship is taking up mandamus appeal, my lord. Kindly takes it up on tomorrow at a priority basis.
Give the notice to the other side if somebody is appearing.
Yes, we have given a notice, my lord.
Yes.
Let the matter appear tomorrow, my lord.
Yes. Give. Yes.
Yes.
My name is not appearing in the order sheet.
I am grateful to you, lord.
What?
Obedient Sarkar.
What is that?
In place of Aditi Sharma.
No, no. What is this? What for?
State actor. Inclusion.
No, for what? What?
Name for correction.
Oh, correction of the name.
Yes, sir.
Which name has gone wrong?
Aditi in place of Obedient Sarkar.
Typographical error ache dekhe now. To be mentioned tomorrow. Yes.
My lordship, extremely sorry for the inconvenience of the court. I am just submitting the matter. I am ready with the matter. That is item number 214.
Yes.
And that was filed on 30th of January.
Correct.
All right.
So what?
Sir, I am ready with the arguments.
So you want to walk over the other matters?
No, sir. I'm just asking. I'm just taking permission from the court that I am ready with the matter today. I have.
We are also ready with the matter, provided the matter is argued by you. No difficulty, because 2 days last week it was lost, nobody appeared. If you are ready with the matter, then nobody appeared on 2 days. So wait, let the matter be called. Let us see. We'll take up. Don't worry.
Miller.
We'll take up.
Miller.
I know there's no difficulty. You know the law better. Come ready with that. We'll talk. We'll have an interaction on that. Don't worry. We'll take up.
Miller, may I be permitted to mention Miller? This is mandamus appeal, Miller. Ready for the hearing, Miller. So that may be fixed tomorrow, Miller.
The entire circuit is lost.
Miller.
Yesterday we could not do a work. Anyhow, we don't know what we'll do.
Oblige, Miller.
Pass by. Sitting with. Yes. I do not know. Just give.
My lord, this,
Yes,
this
yes.
is regarding a civil appeal, my lord.
Give.
Interim application for stay is pending, my lord.
Give. We'll take up on Wednesday. Don't worry.
As you please.
Let us see what priority it will be given. Let us see. Yes.
Get permitted to mention a matter for inclusion in the list, relaxation of anticipatory. 2 matters.
Yes, give.
Your Lordship, I'm mentioning CRA 73 of 2023 was filed on 7/12/2023 and the appeal was admitted on 11/12/2023. So, Your Lordship, kindly list the matter by tomorrow.
Why?
Your Lordship, the appeal has already admitted, but
But whether the paper book has been filed, it is prepared, local record has come, everything has to be seen, madam, first. Without that, you can't expect the hearing to be done. There are certain formalities which are required.
Your
Look at it, whether it is otherwise ready for hearing, then we can definitely include it. Yes.
Lordship, may I be permitted for mentioning for application, one for application and another one for review application?
Review of whose order?
Order of this bench.
This bench means sitting with us?
No,
Both
no,
then
Lordship,
who?
previous bench.
Previous bench, then review has to be heard by that bench. You can't hear, we can't hear it. If both the judges are available, then we'll have to go and get review application.
Lordship, and the application one,
Application you gave? Yes, call the list. Give.
There were a few mistakes in the order, for that we had filed this application, but the petitioners have already enlarged on bail, so the application has become illegal.
No, there was an order, previous order was there. We are surprised to note that it has not taken any steps for apprehension of the petitioner in spite of the rejection of the prayer for anticipatory bail.
Already taken into
So
custody.
report was there, and now the report says that both the accused, they are, one of them got Sandeep Kanu, who is this, one of the accused, has been arrested. And he was immediately granted bail within 7 days when anticipatory bail was rejected.
That was the decision of the court below.
And Naveen Gupta, he surrendered and also got the bail on the same day. Sorry, 29, and within 4 days, he got bail. Very interesting. What are you doing? You said, what your counterpart was doing in the trial court?
Lordships,
What is the allegation?
allegations that he sold the property to the defect that he is the only legal heirs. And subsequently, they came to know that he is not the only legal heirs. Thereafter, he creating pressure and dispute cropped up. And your Lordship,
Civil dispute, Lordship, civil suits are pending.
Huh? It is submitted by the counsel for the petitioners, both the petitioners, that the instant application for anticipatory bail, though rejected on though rejected on an earlier occasion, but subsequently they surrendered before the jurisdictional court.
One of the petitioner was arrested, another was arrested.
Kivarchi, the petitioner number 1 surrendered before the jurisdictional court, and other after being arrested, and the other was arrested. Subsequently, they have been enlarged on bail by the court below. Therefore, the instant application for anticipatory bail has virtually become infructuous. In view of pursuant to the order dated 13/12/2023, the report is submitted by the investigating officer. Stop. In view of the above, the instant application is dismissed as infructuous.
Milord, I am for the petitioner Milord. This petitioner was convicted on
Suspension of
Milord,
sentence.
Milord,
You have been charged under which provisions?
326 Milord,
Conviction under section 3.
Only,
only Milord. And when he was on
and
bail,
7 years imprisonment.
Milord.
Yes,
Milord, when he was in bail, Milord, during the trial, Milord, he didn't misuse the liberty granted by the court.
he
Milord.
did not, or he misused.
He did not, Milord. And he has got seated mother, Milord, and 3 children. And he's the only earning member in the family, Milord. And there is possibility of success of.
What is the nature of the grievous injury?
My lord, there was a sharp cut injury on the leg and the victim is physically handicapped. The position is there. That is running page number 7 of the main petition. For the suspension of sentences. Page number 9, my lord.
Is a physically disabled.
Whether this is a punishment of 7 years, whether division bench can have on the single bench.
Oh. Single bench, up to 7 years, single bench. Is a maximum punishment of 7 years, then single bench. As per our rules, can't be.
Conviction 7.
Lako. For want of determination, let this matter go out of list. Liberty is granted to the council to mention the matter before the single bench. Yes, correct. Up to 7 years. Thank you. It didn't struck my mind.
Maybe permitted, Milord. Milord, I am yet to complete the service to the victim, Milord, in this regard. This is 376D, Milord.
You have not affected the service now.
Milord, yes, complete.
Service is incomplete. Let the matter be listed on Friday. Give it. Where is Miss Ashmita Mukherjee? Which district? Darjeeling.
District,
Darjeeling.
Darjeeling.
302. Life or
Life.
none appears in support of the application. It appears that the appellant is not interested in pursuing the instant application. The application is dismissed for default. Where is Mr. Surup Das? Where is the application? He took the business stage, and he's not pursuing. He took the business stage. Kuch nahi, it's a victim, it's a victim's appeal. Out of time, देखिए section 5. नहीं हमने हर चीज की वो section 5 वो नहीं होता है. Where is anybody knows him? Surup Das. But 3 days delay. Anybody knows him?
I know him, not make it possible, or I will intimate him.
Call him. What he's doing?
No, item number 7, Miller, is a legal service matter, Miller. No, I have to file the Miller section 5 application. The person,
That is the earlier one also. That's why we were thinking about.
yes, Miller.
File section 5.
This is the Miller, I have tried to communicate, Miller. The person, the phone number was given by the jail authority, Miller. That the person.
How can a phone number be given?
Phone number of the Miller.
He's in jail.
His sister name was given to file from the affidavit. Miller. This is a communication that I have made, Miller.
So do it by day after
Make it next second, Miller.
day after tomorrow.
Within a month, I could not contact him. I have to contact jail authority to attend someone on his behalf to file the section 5. Next service.
It is submitted by the counsel for the appellant that that he has been engaged by the state legal services or
Calcutta.
he has been engaged by a Calcutta High Court legal services or the committee to represent the appellant who is in custody, having convicted under the having convicted after a criminal trial. Full stop. It appears that the instant appeal has been filed beyond the statutory period of limitation provided therefore, without accompanying an application for condonation of delay. The counsel for the appellant submits that he has made all endeavor to contact the person who is otherwise competent and authorized to swear an affidavit, but all such attempts have gone in vain. He therefore seeks more time to take appropriate steps. So in such view of the matter, let this matter go out of list with liberty to mention.
Item 8 and item 15 are both are similar. Item 8 prepared by the legal service authority and item.
Is by the convict himself.
Yes, madam, convenience, item 15.
And 15 is
Same matter.
through counsels.
Through counsel.
So life imprisonment, 302,
302 and section 6 POCSO.
section 6 of the POCSO Act.
Both.
What do you want?
Madam, I want item 15, madam. So he files this appeal through counsel, madam.
So who you are representing in both 8 and 15?
Yes, item 15.
8.
8, madam, I will be representing. Madam,
I will be. I
Madam,
do.
madam, sorry, madam. If he filed this appeal through counsel, madam, there is no. need-
So where is that? So there must be somebody who must represent him. If he can contact you, then he can contact you as well.
Yes, madam.
So where is that
I'll be appeal, item 15, madam.
The item number 8 is filed by the convict himself through legal services. There must be some lawyer. Who is the lawyer? You don't know.
The jailer. Only.
Can you secure a wakalatnama? We can direct regularization here.
In memo of appeal, I filed the Vokalatnama already.
Oh, that is in 15. In this,
Both are same person. Another Vokalatnama I will be in. If you are not, I will give another.
that is
Vokalatnama.
what we want.
Yes, madam, yes, madam. Yes.
Tomorrow,
Day
secure
after.
it tomorrow.
Madam, day after.
No, secure it.
One day, madam, cannot be possible, madam.
Come on Thursday then.
Yes.
नहीं वो तो जेल থেকে করেছে না একটা এই ডিপার্টমেন্টকে বললো দুটো কপি করতে It's 9. Ako. The instant appeal has been filed beyond the statutory period of limitation provided therefore. When the matter appeared on 3rd January 2024, there was no representation on behalf of the appellant. The coordinate bench, after noticing the aforesaid fact that there is a delay of 517 days in preferring the instant appeal without accompanying an application for condonation of delay, and directed the matter to be listed in the next circuit bench. Today, when the matter is taken up, there is no representation on behalf of the appellant. It appears that the appellant is not interested in pursuing with the instant appeal. Otherwise, as well, the instant appeal is filed beyond the statutory period of limitation without seeking any condonation of delay, and therefore the instant appeal be treated to have been dismissed. Ten.
Item number 10, legal service matter, can you make it 5 days?
Defective, sir. What is the defect?
I have arranged the person.
Again, sir, condonation, you have not.
Person has been arranged, my lord, the jail authority has been engaged a person.
Come on Thursday, do it. Sorry, do it. It was all also on the last circuit bench, you did the same thing. Do it by Thursday. Let's call the next. দেখি কোনো এঙ্গেজমেন্ট হয়েছে না হলে Where is Mr. Aniruddha Biswas?
And short passage.
Call him. Yes.
Well,
দেখি same problem. Where is Mr. Parthopratim Sarkar? Call him. Pass over.
Your Lordship, I am for the appellant. Your Lordship, I have filed the application under section.
5. What?
I have filed the application under section 14A(2) of the ST/SC Prevention Atrocity Act 1989 for the cancellation of bail.
The bail has been granted here.
Oh, Your Lordship, the bail is granted by the trial court of Jalpaiguri.
But why it is appearing as an admission of a criminal appeal? Let us see, which is the order under challenge?
Your Lordship, the order dated 5/6/2023 and order dated
Just 1 minute. 5/6/2023.
yes, Your Lordship.
Yes, why you want this order? There is a provision for an appeal against the interlocutory order under the SC/ST Act.
Your Lordship, there is provision. 14A.
Let us show us, sir. We want to know the law straight. Where is the act? Where is the provision of an act? Where is the act? Please show us the act, madam. You are moving a matter. You should carry the statute with you.
Your Lordship, I have given 2 minutes. I have in my file.
Where is your file?
The photo.
Yes, take it out. Fourteen
14A,
A,
2.
capital A,
Yes, sir, 2.
just.
Your Lordship, it states that we can go for appeal when bail granted or rejected by the trial court.
No difficulty. No difficulty, we have seen, because the first subsection actually disallows such appeals to come, but subsection 2 is there. Yes, then tell us that why this order is bad.
Yes, Your Lordship, kindly go on page number 8.
Yes,
8 to 21. That
Yeah.
is the messages done by the respondent
Page?
number 1. 8 to 21. That is the screenshots of the messages.
was it produced before the court below?
Yes, Your Lordship.
Trial court?
That is mentioned in the order number, Your Lordship. That is mentioned in the order number. Your Lordship, Your Lordship, 6 January 2020.
Now, what are the ingredients under this act? In order to constitute an offense under this special act, what are the ingredients?
Your Lordship,
What has to be done?
Lordship, the applicants belong to the SC.
That does not mean there must be something in relation to a caste or a tribe.
Yes, yes, Your Lordship.
Any other abuses not relatable to a caste and a tribe, does it come under the purview of this act? I'm just wanted, that's my question to you.
Yes,
Sure. What are the offenses under the act?
Your Lordship, the respondents tried to defame the appellant.
That is a different issue, madam. Again, I'm saying, in order to robe a person within the ambit of this particular SC/ST Act, there are specified offenses that should be there. Mere defaming a person without any reference to a caste or a tribe, whether that defamation would come within the purview of this act, I'm just asking you.
Your Lordship,
If any abuses, anything which is done in relation to a caste, then it will come. If it is a general words, whether it would come under the purview of this. This is what I really wanted to know from you.
Your Lordship, kindly go on page number, last second page of.
I have seen the entire the WhatsApp messages.
Your Lordship, that is the order of trial court.
No, order of trial could have gone. I have gone. And you are relying on that particular, the exchange of WhatsApp messages. Definitely, it's a very, I would say, abusive languages, the inappropriate languages, I can understand. But is it relatable to a caste? Never. Not a single word relating to caste has come. If that being the position, you can definitely go for a defamation, no problem. You can go for that.
Your Lordship,
What are the provisions? 540 or something like that? I do not know. 49.
Your Lordship,
You can go for that. But what about SC/ST? I'm just simply asking you this question.
Your Lordship,
The words and expressions used but not defined in this act and defined in the Indian Penal Code. So then should be due to be specifically assigned to this. I can understand. Punishment, whoever not being this assessor puts any inedible or obnoxious substance in the mouth of a member of the assessor. To drink, eat such a inedible or obnoxious substance. Dance, scrita, economy, with intent to cause injury, insult, annoyance to any member of the schedule. Also, dance with footwear or something. Maybe the member of the sitting around. Possibly commits on a member of the judge act if you remove it, yes, it's not good. Occupies the cultivates any lands. Not fully. No. The forces are intimidates not to cast vote, not to file nominations, not nominations. The vote is Jabbar. In the case with the public view. Bypass, easy picture. Easy Jagata, this is what is. No.
Your Lordship, the case has already instituted under section 3(1).
Madam, there are two aspects, sir. Madam, so far as the initiation of the case is concerned, it will definitely undergo a trial and he will face the trial. You have to stand on your version, which you have said. What would be the outcome of the trial will be decided by the trial judge. Now, the question of bail is concerned, the court has to form a prima facie opinion on that, whether the custody trial is at all necessary or the custody trial is not necessary. And if the court is of the view and finds that there is no difficulty in proceeding with the trial when the person is granted a bail or enlarged on bail, then in that event, there is no difficulty when the court exercises the discretion. I was just trying to look at, because the trial court has recorded that till this time, when the witnesses have come, not any incriminating or any materials is forthcoming, which may lead to serious offenses having been committed. Now, you have seen the latest judgment of the Supreme Court. The guidelines for granting the bail has been elaborately discussed, and one of the guidelines is the gravity of the offenses and the consequences to flow therefrom is also one of the ground. Secondly, culpability of that particular person in the commission of an offense is also one of the very, I think, the relevant factor one should consider. You are banking upon those WhatsApp messages.
Your Lordship,
Prima facie, after reading at it, I was just looking at those provisions emanating from Section 3. Satisfy us that any of such ingredient from this WhatsApp exchange is there.
Your Lordship, kindly.
Just tell us. Don't utter those words, very obnoxious words, don't utter in open court, but whether anything relatable to a caste.
Kindly see the page number, last second page number. That is the order dated 9/8/2023
Correct?
of the trial court. Last
Yes.
second page.
Yes. Yes.
That is the order dated 9/8/2023.
Correct.
Your Lordship, there it has mentioned that the IO of the case has submitted CS against accused person, namely Mustafa Ansari, Sarita Groom, wide CS number 90/2023 dated 31/7/2023
Three.
under section 448, 323, 440, 342, 379, 506, 420, 34 of IPC, read with section 3(1)R
R.
of ST Act.
Correct.
Your Lordship, kindly go the next para. Next para of the.
And we have already marked those are after reading the entire section.
Your Lordship, this is the order of the trial court. This is the order of the trial.
It says that the charge sheet has been submitted, the cognizance has been taken, the charges have been framed. Does it mean that the bail cannot be granted, or a bail granted before the charge sheet is submitted should be cancelled in this regard automatically?
Your Lordship,
It's a prima facie opinion. It's a prima facie materials which the IO investigating officer found. Does it mean the moment the charge sheet is filed, the conviction is automatic? Is this a law? No. If that being the law, that it is not an automatic, then what do you say?
whatever annexure I have annexed with my petition,
Correct.
that is committed by the respondent after the bail. After getting bail, whatever annexures I have annexed with the petition.
Why don't you move to the trial court saying that you have granted a bail, he is misusing that particular bail. Now you can cancel that bail. Why? When you are making an appeal, filing an appeal, then you will have to justify that on the day when the bail was granted, there was a material before the court which does not invite the grant of bail. I can understand. If anything subsequent event has happened, you go and apprise the court who has granted the bail.
Your
Approach the court.
Your Lordship, all the documents already have submitted before the trial court.
Please, then what the trial court has not decided as yet. So, but you are assailing the parent order.
Lordship, but they extended the bail of the.
Then you will have to apprise the court that you will have to dispose of the matter. You can't do it. You have to decide the matter.
And your lordship, as the case is instituted under STSC Act, that's why I have to go for appeal under the.
No,
STSC
then
Act.
appeal is against an order of 5/6/2023, madam. This appeal can only lie against an order dated 5/6/2023 when this application for bail was allowed. Not subsequent thereto.
Lordship, second respondent had got bail on 22nd/6/2023. That's why I annexed that.
What?
That order.
20?
22nd/6/2023. Second
Yes.
respondent had got the bill.
Yes.
That's why I annexed that.
But you have not annexed the order. Which is the order by which the second respondent got the bill?
I have annexed your lordship.
Yes. Yes, that is the 22nd of June.
Yes, yes.
Yes, no difficulty. Where is the problem? Where is the problem? Cognizance, the charge sheet was filed there later on.
Your lordship,
Yes.
your lordship, after getting bail, as he harassed the appellant.
Madam, then what is the law? What is the law? You are referring this section 14 capital A to me. 14 capital A says, notwithstanding anything contained in subsection 3 of sections 378, an appeal shall lie to the High Court against an order of the Special Court or the exclusive Special Court granting or refusing bail. So, if at the time of granting the bail, if he has not taken into consideration certain documents, you can definitely say, but you are saying that no, subsequently, this is after the grant of bail, something more has happened. If something more has happened, this did not happen on the day when the bail was granted, then the appellate court is supposed to do what? The circumstances, the material which was available before the trial court as on the date when it passed the impugned order. If there is any misuse of the liberty being granted, you can approach. You have already approached. So let that be expedited. Unnecessarily, I think still you have not understood the point which we want to convey.
Your lordship, then.
Because your facial expression shows that you are still in dilemma or in a great confusion.
Your lordship, then I would like to not press the.
না ঠিকই অবজারভেশন আমাদের করে দিলেই তো বিপদ আছে না সেটা তো আমি তো অ্যাভয়েড করতে চাইছি The counsel for the appellant submits on instruction that her client does not intend to press the instant appeal as he decided to pursue his remedy before the trial court. So in such view of the matter, the appeal is dismissed as not pressed. Liberty is granted to the appellant to pursue the remedy before the trial court.
Great, your lordship.
My lord, I beseech your lordship, my lord, item number 5 was dismissed for default, my lord.
What can be done, sir?
My lord, I have asked 2 of my colleagues to come and take passover, but they both failed to do,
So
my lord.
what can
My
be
lord,
done?
it can be taken up as passover, my lord, because ultimately it is a bail in connection with appeal, my lord. I come all the way from Shiliguri, my lord.
Pass over for the timing. Let us see.
My lord.
Don't record the rejection order, dismissal order. Let's call the next. Hmm? then we have to appoint an amicus curiae because it is a jail appeal. What should be done? Some appointment through High Court State Legal Services Committee or amicus curiae?
Both may be point or both. Both the practices are pretty.
There is no Aniruddha Biswas. Who? You? Then you are appearing for them.
Lordship, I was not informed. Can I just see the order?
No, no. And what about Shomajit Datta? Shomajyoti Datta.
The district court practitioner is in the panel of the.
Anybody who does not represent the state, tell him. Who does not represent the state. Whether he is coming, Arijit Ghosh,
Not in the state.
where is he? Instant appeal is filed by the appellant while in jail. There is no representation when the matter is taken up to the. He therefore appoint Mr. Arijit Ghosh, who is the panel advocate, who is the panel advocate of the Calcutta High Court Legal Services Committee at Jalpaiguri, to represent the appellant, assisted by Mr. Saurabh Ganguly. Saurabh Ganguly is appearing.
I appear on behalf of the state also.
I wanted to give one junior with him so that at least the. No, I know. Abhijit is junior to you. Oh, you are of 99. I just noticed, unnoticed. Yes, with Miss Rima Sarkar. She does not appear.
No, she's my batchmate. She is also senior.
Siddhi, sit here.
Same batch, senior.
No, for the state or what?
No, Siddhi is not for this.
Then can't she appear because her enrollment date is 10/11/2008, whereas Abhijit is 4/9, so he is senior by at least 2 months. Huh? No, the Siddhi. Siddhi sit here. She does not appear for the state. Siddhi sit here. All formalities relating to such appointment be undertaken. Let the matter be listed in the next appeal. Next. Oh, yes. When you were secure, when with the other, Thursday, along with the eat. For করবে. Yes, next. জেল থেকে এসছে। হ্যাঁ? না ওরা পয়েন্ট না হলে তো হয়। এই লিস্টটা দাও। What about Bhaskar Rai Mahasoy? Is he? Anybody knows? So he appears,
He appears here.
not for state.
No.
Yes, Bhaskar Rai Mahasoy, number 2. He's a senior category A lawyer with whom. What about Arjun Chaudhary? State. What about Swarnali Sengupta? He does not.
They appear on the central government, but now she has.
Yes, Swarnali Sengupta. He category B te C te want. Next. Arey, ওটা দাও। List the. Devojit Kundu? You are for the state you appear. Then who?
It doesn't appear.
No. Arjun Chaudhary. Yes. Category B there. Oh, I can't. Yes, call the next. দাও কেউ থাকবে না দেখি POCSO. কপি দিয়েছি আগেরটা সেম POCSO related to দুটো দুটোই POCSO ওর কাছে সুবিধা হবে
I'm for the petition, my lord.
POCSO related to ওখান থেকে তো who is appearing?
I am for the petition, my lord. My lord, actually, this fact is relates to bail. But if your lordship, can you take the page number 12? On earlier occasion, the petition was not pressed because the 439 has no application because section 3 of Prevention of Atrocities Act is there. So we have to file a bail application by the way of section 14A subsection 2. And by that way, I have filed. And we have, as the
None of the special statutes have been spared against you.
my lord, that is the unfortunate incident I have seen.
Unfortunate.
Now,
What is the age of the victim?
My lord-
Sorry, hey,
my lord, so far,
this is a POCSO related matter, please.
my lord,
What is the age of the victim girl?
one indirect.
Where is Miss Namrata Das? That's the state's appeal. Cancellation of bail. Let us see.
Number 21 and 22 lordship. These are both are state applications. One is for cancellation of bail, and another is for transfer of proceeding from carrying company other.
What is the,
In this matter, lordship, Mr. Milon has connected CPA.
What? Seat?
He has, he was ready, but he has informed us that one of his neighboring principal is continuing. He has requested to. Keep the matter to vote.
Why not today? Why not today? That will continue for the whole day, or it will,
It takes some time. I have
What?
to check and.
we are keeping at 2 p.m. If he is there, then you'll have to move it. You'll have to move it. Come at 2 p.m.
I am for the opposite.
Yes.
Well, item number 23, my lord. I'm representing opposite party number 2 and 3. I'm led by Mr. Oyon Bhattacharya. He's on his legs in courtroom number 32. I was praying for a short passover or at 2 p.m.
No. Let us. What is this?
Matter,
My
my
lord,
lord.
it's cancellation of bail, my lord. I was only
Pending.
praying for a short passover, my lord. Short passover. He's leading me in this matter. Short passover.
My lord, there was a proceedings before the Honorable Supreme Court. And that proceedings was also dismissed.
My lord, we are not audible. Lordships, you are not audible.
I have not said anything as yet.
My lord, much obliged.
There was a direction to file affidavits.
My lord.
Has it been filed?
My lord, only one of the opposite party has filed. My lord, the remaining has not.
Oh, the
Well,
opposite party number 2, 3, 4,
Four has filed.
4 has filed. 2 and 3 have not filed.
No.
Okay.
Well, opposite party number 2 and 3. I'm representing opposite party number 2 and 3. It is my instructions that the affidavit in opposition has been filed. It is with me.
But, sorry, we do not find from the record whether, let us see.
My lord,
Any copy served on you
No, ma'am.
regarding the opposition?
Not only 4 has served.
2 and 3?
No.
Yes, even in opposition, I find one. Yes, 2 and 3 is on record.
My lord, not served on me, my lord.
Is on record.
my lord, this is
Served.
No. No, my lord.
my lord. May I clarify, my lord? This is actually a changed brief. The earlier advocate record may have filed the matter. It has come to us only this week. If the service is not complete, kindly gives me a day's accommodation to at least serve on the opposite party.
We
Because
fully appreciate. Once you have inherited the asset, you must inherit the liabilities as well.
Yes, my lord. Just
You are blessed with the brief being transferred to you. Then you should be more vigilant, should be more careful, and should ensure that you do not ask for an adjournment simpliciter on such ground.
my lord,
Have you not ensured when you accepted the transfer brief that what has been happened in the matter is it not your duty to
Yes.
first make an inspection of the record and find out what has been done and what has not been done? You can't take a court for a ride that I have accepted. I am blessed with the transfer brief, so grant me an adjournment.
My lord,
Is this
that
a
is not
ground?
my lord, please do not take
Let
me
the
amiss.
country know, because we are live streamed, that this is what is happening in the judicial system.
My lord, please do not take me amiss. I
But
was instructed.
definitely, you do not know whether it has been filed.
Madam-
We say, have you served? You do not know
No.
what erstwhile advocate has done. We don't know.
Ma-
We don't any bear responsibility for that lapses done by your erstwhile advocate.
My lord, when my lord asked if the matter has been filed, the the advocate appearing on behalf of the petitioner said it has not been filed. Then my lord had checked. I had already said it has been filed. My lord has
Sir,
checked
when
the
I
record.
asked
The
whether it
service-
has, he said no service.
Yes, my lord.
Then you
The
said
service-
you have accepted a transfer brief, you do not know. That means you are really shying away from the
No,
responsibility.
no, my lord. No, my lord.
That shows that you are shying away
we-
from the responsibility.
My lord, we had instruction. It has been filed. If the service is
Then
not
why
complete,
the service has not been done?
my
It
lord,
is only for the court purpose, or the other side must
My lord,
know
I'm
that
tendering-
what he has
my
to,
lord-
what case he has to meet.
my lord, I'm tendering my unconditional apology. I'm taking only, my lord, I would ask for a small, if passover, because I'm led by Mr. Bhattacharya. He's
Sorry, this can't be, a senior cannot be a ground that the senior advocate. Then what for you have been engaged? Will you not start your case? I am asking you a simple question. Why the affidavit in opposition, which you have filed in the court, not served upon the petitioner or the appellant? Why?
my lord,
It has not been served.
my lord, I'm taking responsibility for what are the
Then you will take your opposition
My
on
lord,
record. Will
kindly,
not take, because he has
My
not
lord,
been given an opportunity to peruse that.
my lord, kindly,
And
it
this
is
is
an,
another disadvantage, that you are getting the adjournment in the matter.
my lord, it is an inadvertent mistake, my lord, on whoever. I am taking responsibility. I am only seeking for a short adjournment on
No
the
short adjournment. Serve a copy here and now. Serve a copy here and now.
My lord,
No, we don't appreciate the
No,
way
my lord,
your junior has
I do
conducted.
my lord, I do.
What is this going on?
No, should not have been, my lord. No
There
doubt
was a
about-
specific direction by the earlier coordinate bench to file an affidavit in opposition. Respondent number 4 is filing it. I asked
lord,
2 and 3.
definitely, my lord.
The appellant says, I don't know because I have not been served with a copy.
My lords are
And
absolutely
conducting
right.
advocate junior says,
No, my lord.
no, it has been filed. Then we noticed
no.
it is there in the record. We asked him. He says that we have got a change brief yesterday.
No, it's no excuse, my lord.
We
Change
don't
brief I
know.
should not have accepted.
Is this
In
a
that
way?
case, should not have been accepted, right, my lord? No.
Why you
no,
accepted a change brief before
My lords are absolutely
making
right.
inspection of the
Should not have
record?
accepted. Should not have accepted. But what I just beseech, my lord, if it can be day after, my lord, in court.
No day after business. These matters were not touched when we came in the circuit. Last week, only one available day we could
I
avail.
know. My lord, why day after, my
Entire
lord, I'm-
week was wasted.
Well, I know that. I know that. But why day after, my lord, I was beseeching, my lord. I will be
Because we
doing
have fixed the
physical-
civil matters, we have to deal with civil matters as well.
No, I know, my lord. I will be doing physically, my lord, if I have that privilege, my lord.
Sorry,
I just
tomorrow
take 10 minutes,
and
my lord.
today itself, you must be served before recess.
My lord, it will be served before recess, as my laws have desired. I ensure that. But day after, I will do physically if my
No,
lords-
tomorrow. The day after will not be.
No, actually, my lord, for physically, I wanted to do this, madam. Only
No,
for
day
this.
after.
But
Day
I'll just
after
take-
is a civil matters that is fixed on the day
My
after.
lord, actually, I wanted to do physically. My lord, I will take 10 minutes, my lord, by the
No,
clock. I assure
tomorrow.
you, my lord.
To
My
do
lord,
it tomorrow.
My lord, I will do physically, my lord. Please, my lord. I will just take 10 minutes by the clock, my lord. Day after. I assure you, lord.
No.
Day after, by the clock, 2 minutes, 10
This,
minutes, my lord.
you have appeared in many matters. This assurance has gone in vain. We have an experience.
My lord, in that appeal, my lord, I finished early. Your lordship has said
No,
that. yes.
no. It was a 15
I took
minutes
one.
assurance which went up to 1 hour.
My lord, here 10 minutes means 10 minutes.
No,
my lord.
no.
I assure you,
Tomorrow
lordship.
at 2
Well,
p.m.
I wanted to do, no, my lord, then I leave, my lord, whatever my lords will say, but I wanted to do it physically, my lord, please, my lord. It's a cancellation of bail matter, my liberty is at
Whatever.
stake, my lord. My lord, so the day after, my lord, by the clock, 10 minutes, my lord, I'm assuring your lordship. I'm assuring your lordship, my lord. Not more than 10 minutes, my lord.
And my lord, this by first half the service will be affected. My lord.
Yes, this will take some time.
Now everybody has heard it. He will not take more than 10 minutes.
Not more than 10 minutes. My lord.
Yes, the respondent,
obliged.
the opposite part, the respondent number 4 files affidavit in opposition. Come on. The copy whereof has been served upon the counsel for the appellant. It appears that the respondent number 2 and 3 have also filed affidavit in opposition in terms of the order passed by the earlier coordinate bench, but the copy whereof has not been served upon the appellant as yet. The counsel for the respondent number 2 and 3 assures this court that the copy whereof shall be served either served on or before the recess, and prayed for the listing of this matter on Wednesday. How much time will you take?
Lord, 10-15 minutes.
Let this matter be listed on Wednesday to be taken up at 10:30 a.m.
Deeply obliged.
Lord, this only in response to file a report.
You are for the respondent number 4.
File the report.
My lord, I am for 2 and 3.
No, Mr. Ganguly.
Consideration by your lordship.
Yes.
Yes, I'm for respondent number 4. My lord, we
4.
have filed a CRAN 1.
So we are fixing this matter day after tomorrow because.
Very well, madam. Yes, I gather Mr. Bhattacharya is.
I'm deeply obliged for the
Come.
obliged.
There was a direction upon the state to file a report with respect to the CRAN filed. So kindly, direction.
Where is the report? Come ready with the report. I have not gone through the records. So come ready.
Deeply obliged for the
Whatever any report is supposed to be filed, then you have to file that report. You can't shy away from that.
Grateful.
Yes.
Deep.
Yes.
My lord, item 24.
Yes.
My lord, I am appearing for the petitioner. This
Move.
is a appearing
Other side, who is there?
for the first time. Are about to come back, and a couple had been, my lord, compelled to commit suicide. Anticipated bail was rejected by the Supreme Court within 16 days. It's a sessions tribal case. Magistrate granted bail. In spite, my lord, anticipatory bail rejected by the High Court and my lord Supreme Court. In spite of that, it's a sessions tribal case. My lord, bail has been granted within 16 days.
Now, Mr.
First time appearing. Yes,
Mr. Mondal, Mr. Mondal,
let me have.
Mr. Mondal, the state lawyer says that the copy of this application has not been served
My
upon.
lord, let me, it's the first time, my lord, let me serve and came back. Your lordship fixed a date.
Thursday, come, serve it today
Yes,
itself.
my lord, nobody is there. I am here, my lord. That's why it's problem, my lord.
Sir, send a soft copy nowadays. Mr. Mondal, use the technology.
Yes, my lord. Yes.
Serve the copy, the soft copy
My
upon
lord, yes,
them
my lord.
in course of this day.
My lord, email address not, my lord, gather, my lord, so far accused opposite party number 2 is concerned. Though he is practicing advocate in my lord Jalpaiguri court.
I could not get it. What do you want to say?
My lord, kindly please after week, my lord, I am sending it by post.
Sir, you must have an email of both the opposite party number 2 also.
My lord, I don't have any, my lord. so far opposite party number 2.
You are not interested. You are not interested, then what can be done?
No, my lord, should I start then tomorrow?
By tomorrow,
By
Thursday,
যেতে হবে tomorrow.
service of the copy of application upon the opposite parties, the
My
respondents.
lord,
matter to appear.
may I serve upon the local police station, and local police station will serve the copy of the application?
Sir, do it,
Otherwise,
do it,
not completed.
do,
Service will not
do
be
it.
completed.
You have a junior here, tell him to do it.
Well, nobody is appearing on behalf of the petitioner. That's why, my lord, I filed my junior went there and filed.
How
this,
can he?
my lord,
Now
cancellation.
I am seriously,
Nobody-
Mr. Moore. Yes,
Yes, my lord, nobody is appearing in Jalpaiguri Court, my lord, High Court. Nobody, no advocate is appearing. We have
it's a very
My lord,
serious,
he is arrested already. Yes, my lord.
why nobody will appear?
My lord, nobody is appearing in this case. No advocate is appearing. Because he is a practicing advocate in Jalpaiguri Court.
Who?
Jalpaiguri Circuit Bench Court. My lord, the
Who?
opposite party number 2. Opposite party number 2.
Is it so? What is this case? I have not
Yes,
gone
my
through
lord.
that.
Allow us to post. কি অর্ডার না আমরা যে রিপ্রেজেন্টেশন আমরা অ্যাপার্টমেন্ট তো দিয়েছি আপনি হাইকোর্টের অর্ডারটা দেখেন কতক্ষণ হাইকোর্টের P14. P14, my lord. Page 81, 79. Page 81. Page 81, page 79. Page 81 and 79. The earlier advocate who had appeared. Page 79 and my lord 81. Earlier advocate who had to suffer the loss.
Page?
My lord, page, my representation, page 79.
Earlier advocate's representation.
Earlier advocate's representation. In spite of, my lord,
Just 1
everything
minute.
and affirm has been done. should
Just
not
1
be filed
minute,
by
1
the-
minute, 1 minute.
Para 19. Para 19.
Where is Mr. Sojit Singho?
Is the local one.
Send anybody to serve the copy by tomorrow. Matter is fixed on Thursday. Do it.
Grateful, man. Grateful.
Call the next.
But I'm for the petition, but this first time appearing, but kindly
So-
give me the direction to serve a copy upon the opposite party number 2.
But I'm holding the, yes, Daddy, my lord.
What about two who has been granted bail?
But after.
At least he has a right to be
Yes,
heard.
Yes, ma'am.
Yes.
Can you serve it in course of this day so that I can fix this matter on Thursday?
But I'll try.
What try? Do it. Service in course of this day, matter to appear on Thursday. Call the next. Service
How about
upon
the petition number?
the respondent number 2. One is appearing.
I'm for the petition, in this matter, I'm appealing for the opposite party number 2. I want to sign my FTP document.
What for? In application for cancellation of bail, I have seen many times the directions, but what is the necessity? It's a matter of record. Nothing, you can't improve something more. What is there on record is to be considered. So let us see. If he says something out of record, you just correct us. Why the bail was granted?
The case initiated at the first instance and again 305. The page number 11, one of the runner session that Jalpaiguri was pleased to enlarge those accused persons on 3 arrest bail.
Yes.
I have annexed the copy. Page number 11, order dated 12th.
So they were granted an anticipatory bail.
They got the footage of anticipatory.
Correct.
If you are to kindly take the page number 9. Was the, which manner the investigation was done?
That was 28/11/2023.
My lord.
And the anticipatory bail
Bail
was
was
granted in
granted
December,
My lord.
much after.
Now, can you see the page number 40? What happened there? The OP number 1 and 2, along with others,
Yes.
OP number 1 and 2, or who we are playing for cancellation of bail, try to create pressure to withdraw the case. Now, on the basis of that complaint, my lord, can you see on the same page?
Already FIR registered and they are.
Let-
Just wait. Yes.
Already FIR was registered against them,
Correct.
and they have been served incarceration. No, my lord, just was the contention of my FIR, that is page number 14,
Yes.
just to create a pressure upon me to withdraw that case. They have tried to kill me also.
No. This is what you have filed this particular complaint, which has been registered as an FIR. The police has taken cognizance on the basis of this, and it appears that in this connection, he has been arrested. He is behind the bar. He has not been enlarged on bail.
No, but
Yes.
nowadays he is on bail. They are on bail.
Now, another question is there are two aspects. One is that the enlargement on the basis of a anticipatory bail order
Bail order.
is one. Another case which is there. Now, both the cases are being investigated.
Correct.
Now, why you want the cancellation?
Submission would be with your lordship.
Yes,
As they, at the first instance, they got a privilege of 3 arrest bail,
correct,
they got it
got
and
it,
surrendered before the
correct,
judicial court and got a regular bail.
correct,
Subsequently, they created a pressure upon me to withdraw your case.
correct.
Now-
So they are violating one of,
Conditions of the bail.
correct. That is what I am saying. The conditions of the bail that is provided under 438(2). There are certain conditions which are provided under section 438(2).
Subsequent case, another.
Regular, correct, on the basis of this page 14 complaint. I know. What do you think that we do not understand?
No,
So there also he has been granted bail. Your grievance is against whom? The first anticipatory bail order or the subsequent one? Tell me.
Bail order is the.
Both cases are different.
Both
And
cases.
yes, correct.
In the first case, that case was initially in 2005. My minor debtor bound to commit suicide due to the mental torture committed by the private opposite party.
Yes.
And subsequently, a case was registered. Now, can you see, my lord, why they got the privilege of pre-arrest?
Why mental torture only?
They abused me, my daughter, whole night over phone. And on the following day, the minor daughter bound to commit suicide by their gestures and words. Now, my lord, can you see, subject to a lawsuit correction, so far the subsequent FIR is concerned, there should be a section should be added. So for my little understanding, 195A.
But that is why you can make an application. Why in this case, the court will say there are provisions under the Code of Criminal Procedure. So even if they submit the final report, the magistrate is or the court is not supposed to go by the ipse dixit thereof. The court, if it finds that there are the ingredients of those another offending sections, definitely it is within its power to do it.
Creating the bail, they are creating a case. And so by humble submission.
Again, I'm asking you, sir, against which order you are assailing, the anticipatory or the subsequent?
Anticipatory bail.
Anticipatory.
Anticipatory. That is my submission. But so for the latest development, that is based on court. After getting anticipatory.
So let us hear him. What is this?
Actually, the case diary of the second case is required to be.
Why?
Because
there was something which has happened because the anticipatory bail was granted with the conditions, and those conditions are there in subsection 2 of section 438. True.
What is the material of 300 that can only be deflected from the case diary?
But whatever is there, the case is still at the nebulous stage of an investigation. If this is the position that you have been enjoying this, and these facts have germinate subsequent thereto, then why not the court will take into account and.
Without the allegation made against the opposite party number 2, there are true or false that can only be ascertained for the case diary.
What is your reaction to it? Have you found any kind of a material that he, after this anticipatory bail, he have been putting a pressurization? Is putting a pressure, something, then you registered this FIR, you arrested it, having found some kind of a incriminating materials disclosed.
Page 14, my lord, that case study is required, my lord.
Page 14.
14. With regard to PS case number 1022 of 2020.
Immediately ensure that by 2 it comes. Which thana? Malbajar. So tomorrow, as a first matter, ensure that it is come. Let us see. Yes, we are coming within 2 minutes. Inform him to come. So many cases. Yes, many people have been granted bail or not. Our record shows that they have been granted bail. Why you wanted? Who is for the? Is in connection with the same case? Yes? Yes. One, I do not know. He was granted a Sadhon Boiragi was granted bail on 2/2/2023 by this court. Then subsequently, I find another application was rejected. Why? In connection with a different case. 162. Why? Within a span of three days. Why?
May I go? A moment to say. On 2nd December. 2nd February, the Prime Minister got the privilege of bail.
Correct. But I find in May, 10th May order, very interesting. Because the prayer for bail was rejected. If I am really surprised. How? Sir, on 2nd May, February 2023, this Sadhon Boiragi was enlarged on bail. I find in connection with the police station case number 162. 162. Our record shows that there was another application for bail filed by the Sadhon Boiragi, which is 425. I'm really surprised that 425 was on 29th November 2022, where he says he does not intend to proceed with the appeal. Then 425 dismissed. Then there is another DRB case number 146 of 2022, which is rejected on 10th of May 2022, saying that he is already there languishing in jail for 376 days. If in the month of February he is granted bail, then in the month of May, how can he remain in custody for 376 days?
So within my knowledge, I am praying for cancellation of bail.
Mr. Sudeep Guho. No, for the petitioner. And on 2nd of May, Mr. Sudeep Guho appeared. Our record shows same case number 162, police station case number 162 of 2021. Yes.
That is, that's not within my knowledge. He can apply.
এটা দেখো আমাদের রেকর্ড 2/2/2000 Oh, 23. Oh, sorry, I stand correct. That was earlier 2022. I'm sorry. I stand correct. Yes.
Earlier his prayer was rejected, subsequently. In the month of February 2023, he got the
It says that out of 5, 4 have already been granted.
bail. But so for the allegation is concerned, my lord, can you see? In the Sadhan Boiragi was the principal assailant. And there are two eyewitnesses. Number one eyewitness is the petitioner here, who is seeking for cancellation of bail of Sadhan Boiragi. And so for the second part is concerned, who also witnessed the incident. That is my lord, page number 30.
Who is appearing for says Sadhun Boiragi?
Yes, I.
Okay. Yes.
Charge sheet witness number 9.
Yes.
Charge sheet witness number 9 and the petitioner of this case witnessed that incident, that the Sadhan Boiragi assaulted the victim, subsequently the victim succumbed to his injury. No, my lord.
The trial has commenced.
No. So from my
Yes, something.
my part. No, my lord, can you see the page number 50?
Yes.
Being aggrieved by that particular Sadhan Boiragi, we went to the Jalpaiguri PS. Jalpaiguri police station received the tape, but did not take any step. Subsequently, page number 17, my lord, can you see? We have informed the matter to the SP Jalpaiguri. By who? That is the eyewitness, another independent eyewitness. Then the charge sheet witness number 9. He was also threatened not to stoop against that Sadhan Boiragi during the course of trial.
Yes.
And for that reason, who had no intention to implicate himself in this case.
Correct.
Accidentally or unfortunately, who witnessed the incident when Sadhan Boiragi committed the offense.
Yes.
And for that reason, if that person, particularly the Sadhan Boiragi's bill, has not been cancelled, the entire trial will be frustrated.
May I say something?
Yes.
Malad, this is a mere allegation, Malad. And Malad, after granting bail, my instruction is the petitioner is deciding Shilipur, Malad. The incident was happening in Dhusipur, Malad. And Malad, kindly see the allegation. Allegation is that Malad, they came to the house of the Malad petitioner and Malad threatened me. Malad, thereafter GD was Malad lost. But kindly see what Malad.
Jalpaiguri police station is under what jurisdiction?
Jalpaiguri.
That is 45 kilometers away from here.
And Malad, after granting bail, Malad, this petition, Sadhan Boiragi is residing in Shilipur, Malad, for his job. And Malad, this, Malad, we are an allegation, Malad. There is nothing in there, Malad. Kindly ask my Malad, learned friend, what is the police had Malad still about the GD?
So for the page number 17 is concerned, he is not interested with it. He witnessed the incident. He also filed an application to the SP for his protection.
But I am giving the way after granting Malad bail, or to harass me or this.
The petitioner had the intent, maybe had any intention to harass him. So for the charge sheet witness number 9, he is an independent.
They not, he also Malad accompanied with the word.
No, that is your version. That is your version.
But he is also Malad the.
I was just going to remind him because he interrupted you when you are saying that he is interrupting you.
And I am not interrupting.
No, he warned you not to interrupt. Let his, the turn be over.
Vivekanand is also one of the.
Yes, what do you say? What do you say?
This is fact. This Sadhan Boiragi is the principal accused. He is the principal. But thing is that, my lord,
Now thing is one.
Considered only
Have
the
you-
thing charge sheet has been submitted.
Have you
and
noticed,
others who are accused in
Mr.
the-
PP, have you noticed one sentence in the bail order? If I go by the version of the Sadhan Boiragi, tell me,
Bottom line.
trial is going on in which court?
Yet to be done.
Whatever is going on in which court?
Jalpaiguri.
Which court?
But at the past.
ADJ or a DJ or what?
It has not been committed, I think. As far as the case is government will not say that.
But 17/9/2024 is fixed for the evidence matter and WA. For WA for one accused person still is in absconded. That's why.
In which case that is?
This case.
Which court? I'm not asking in which court the matter is pending.
The matter is not committed to trial.
They have said the matter has come to trial.
So which
this is my
court?
knowledge.
Which court?
One of the matters is pending in one track. Well, let me say.
Incident session just already.
This is the case of and Siliguri is not within the Jalpaiguri. It is within the government. How can it be? It's on the leave. How can it be? They have flouted one of the conditions. Why not? What are you saying?
Commitment not done, madam. Still is pending before the chief judicial magistrate.
Of
Jalpaiguri.
have you noticed one of the conditions?
Yes, not leave the jurisdiction of the.
According to him, he's living in Siliguri, which is in the Darjeeling district. Has he not? If he has flouted the conditions, then what?
Report may be called for by.
What remote? He is saying that he is living in a Siliguri for his avocation. Whatever be the reason, and the condition was that he should not leave the jurisdiction without, not without informing, he should not leave the jurisdiction.
But
Then-
part of the word, Okinawa is under the word.
This is Dhupguri. Don't say. I asked thrice where the matter is pending. I asked thrice for that reason. I asked for
They confess, that they left, not comply or.
Okinawa is under the minor Jalpaiguri jurisdiction, but it is under the Siliguri Municipal Corporation.
I am again asking you, when the court, the order is very specific.
Yes, madam.
The petitioner shall not leave the territorial jurisdiction of a trial court. I asked if it is committed, then which is the court which is committing? If it is within the district of Darjeeling, then it's, sorry, but Siliguri, you are saying that he is there.
Half part of the Siliguri under that word.
But you are saying he is residing in Siliguri, which is under the district of Darjeeling.
Yes, madam. Half part of the word Siliguri is inside under the jurisdiction of our New Jalpaiguri police station, New Jalpaiguri and Bhaktinagari is under the word corporation of Siliguri Corporation.
Sir, jurisdictional, territorial jurisdiction is decided on what basis? Tell me. It is for administrative convenience. One is there in NCT. If they say that you will not leave the jurisdiction of the Delhi High Court, or say the Delhi District Court, maybe you are residing in NCT. Does it mean? I'm just asking you. What does a territorial jurisdiction mean? Of the trial court.
He will decide for Jalpaiguri. But is the area comes under the word Siliguri Municipal Corporation.
I am asking, you said that he is residing in Siliguri. I'm just, then what does it mean?
Technically, what Siliguri is under the word
Show us your documents by tomorrow, that whatever your documents are, and where you are working and where you are residing.
Yes, but can you give me one day time or?
Tomorrow, I'm keeping this matter at the first. Show us.
Later development.
You have not noticed. You have not made out a case like this. Not made out a case like this.
Lordship, this is an appeal against acquittal by CBI.
So is an against the acquittal.
Lordship.
What was the case?
My lord, Prevention of Corruption Act.
Oh, there is a delay.
Lordship, there is a delay.
And
974.
kindly look at, satisfy me on this ground.
Lordship.
There is a section 5 accompanying this.
Lordship. Can is there.
Have you served the copy?
Yes. Lordship.
Where is the service?
Lordship, it is, if I am subject to correction by the record, my lord, I think it is already in the file, my lord.
Have you communicated this order of 2811?
My lord, we have communicated since he is lodged in the correctional home. So it is done through the superintendent of the correctional home.
No. He has already been acquitted, so he
But
can't be
there
there
are
in the
4 or
correctional home.
5 cases, my lord. In some of them, he has been acquitted, in some of them, he has been convicted.
He has been convicted. So he's still there,
Yes.
languishing in jail.
We have communicated, my lord.
Or is it? The question is whether the section 5 lies.
My lord, section 5 lies, my lord.
How?
But I think, my lord, in all fairness, he should be given a chance to oppose.
No,
my
that
lord.
was already there because that's why I
But,
asked.
my lord,
On-
since he is in correctional home.
No, 28/11/2023, the court has recorded that application for condonation is filed, affidavit have been filed. So the court says that the opportunity should be given to controvert it, opposition. That's why I asked whether this order of 2811 has been communicated or not.
My
So
lord,
that,
we need
so
to-
that he's
My
communicated
lord,
that he's
kindly
supposed to
allow
file.
me to come back tomorrow.
But,
I will
the second point is the pure question of law.
My lord, whether section 5 is applicable. in
Applicable
criminal-
because the language of subsection 5 of section
Very stringent.
378, it is.
Stringent. But we have to satisfy your lordship with judgments on that count. But
Because
before that, I
because
have
it
to-
says no application under subsection 4 for a grant of special leave to appeal from an order of acquittal shall be entertained by the High Court after the expiry of 6 months where the complainant is a public servant, and 60 days in every other cases computed from the date of that order of acquittal.
Lordship, I have noticed it, Lordship.
So
That I
if
have to show my
language
lord.
is such that it does not bestow the power upon the court to do so,
It appears, my lord, that the courts are bereft of discretion to apply section 5 in case under
apparent.
apparent. Now, my lord, I will try to place judgments of the Honorable Apex Court, which will hopefully demonstrate that my lords are not bereft of that power. But before that, the lordship had put another question to me, whether that 2811 order has been communicated to the respondent, that I need to check, my lord. Allow me to come back tomorrow, my lord, kindly. In both three.
Not today. Second one is also the
No,
same.
my lord, we are a bit different. my lord. We are filing this affidavit of service. Trial.
The point remained the same, whether section 5 lies
Applicable
or
or
does
not.
not lie. So take it back, come tomorrow. We are
Lordship.
keeping both the matters.
Grateful, my lord.
I tell you very frankly why I am asking this question. Because there are certain special statutes where the period of limitation is provided and the power to condone beyond that period is not provided therein. So Apex Court has held that no, the court is denuded of power beyond that outer limit.
Lordship, we are collecting, there is one or two Supreme Court judgments we have come across. There is one coordinate bench judgment of this honorable court. There is one single bench judgment of this honorable court. But I have to study them before pressing them before. And even in another matter, honorable single bench of this circuit has passed a condemning order.
No, we can. There is no difficulty.
No,
But the
let us
language,
have a full
yes, language is such which really creates
Yeah.
no entertainment. Entertainment. Shall be entertained. যে পুরো জায়গাটা করে দিল।
tempo the petition.
6 months or 60 days চলে গেলে entertain দিয়ে হবে। Power to extend সেটা হচ্ছে limitation. Yes, item number.
Lordship, the honorable coordinate bench granted me anticipatory bail. Since then, I am complying with the orders of the honorable court. Lordship, I beg to relax.
Why you want to leave the jurisdiction?
Lordship, I'm a marginal businessman, Lordship. Marginal businessman, I'm Lordship.
What businessman?
Marginal businessman. I have.
Marginal businessman?
Lordship.
What does it mean? I have not come across with this expression.
Lordship, for the business purpose, I have to go outside of my jurisdiction, Lordship.
That means a marginal businessman. What does it mean? Marginal businessman, this expression is not known to me. I understand businessman is a businessman. Marginal businessman, that is what I am asking. This adjective, what does it mean?
Lordship, supply of raw materials from the one district to another district, Lordship.
So that's he's a trader.
Lordship.
He's a trader. I understand, but why a marginal businessman? Who earns profits on margin? What does it mean?
Lordship, he has to go outside of his territorial jurisdiction, Lordship.
What is the case?
Lordship,
399
402.
Read with Arms Act.
Lordship.
So,
Lordship, 1 year has been lapsed after the filing of complaint, Lordship. See,
Yeah.
charge sheet, I think not submitted, Lordship.
Why?
1 year lapsed.
Why? Why? And the case was registered when?
This was registered in the month of February.
February 12th of 2022, Lordship.
So 1 year.
Lapse of 1.
How many, what is the statutory period?
90 days, Lordship.
So, how many 90 days have elapsed? Is there anything which is there that he cannot, he has flouted this condition?
No, Lordship, I'm complying order.
What is his establishment here? What is his establishment here? Does he have the house? Does he have anything here?
According to the directions given by the honorable manager, usually of like amount.
The state is directed to submit the report disclosing the assets as well as the other establishments of the petitioner within the jurisdiction of within the jurisdiction of territorial jurisdiction of the district of Jalpaiguri by Wednesday, the matter to appear on Thursday.
Much of it. Lordship, may I enlighten my submission, Lordship? Lordship?
Possibility of absolution. Then why investigation? Yes. 31.
I am for the petition.
Yes.
And for the statement.
Where is
But
the
order
where is
was
the-
passed on 15 March page 12, please. The order of order was passed on 15 June 2023. And condition is page 13, my lord. He will
not leave the jurisdiction
he will meet the investigating officer
once a week?
once a week, my lord. I am not.
Have you submitted
After-
the charge sheet?
Yes, my lord. Charge sheet submitted. Charge sheet submitted.
So is there any necessity of meeting the investigating officer?
No, my lord, actually. Charge sheet submitted, my lord.
Correct. So after that, is there any necessity? Because it says that to make himself available for questioning
Yes, ma'am.
to the investigating officer once in a week.
Yes, ma'am.
So now the questioning is over.
Yes.
Charge sheet is submitted.
In
No further questioning.
No.
Then why it should remain?
My lord,
He was to meet for meeting a question, answer, or for meeting a question and answer. That is over. But territorial jurisdiction would remain.
yes, yes,
And he will attend the court
yes, my lord.
on his day, default of 1 day.
As because, my lord, this petitioner belongs from Rajasthan, my lord.
For questioning. Himself available. Questioning to the investigator. That's it. So we are aligned. This is an application seeking relaxation of the condition of bail granted to the petitioner on 15/6/2023 in CRM 412 of 2023. While granting the bail to the petitioner, this court, apart from furnishing a bond of the specified amount and the conditions enshrined under section 438 within bracket 2 of the Code of Criminal Procedure 1973, impose further condition that the petitioner shall make himself available for questioning to the investigating officer once in a week until further orders. The instant application is taken out seeking relaxation of such condition as the investigation is over and the charge sheet is submitted to the jurisdictional court.
Yes, ma'am. Yes, ma'am.
Submitted to the jurisdictional court. The said condition was imposed with a view that the petitioner should make himself available to answer the question raised by the investigating officer in furtherance of the investigation. And the moment the final report has been submitted, we feel that there is no necessity of meeting the investigating officer for such purposes. In such view of the matter, the conditions pertaining to meeting the investigating officer once in a week is relaxed with further condition to be imposed that the petitioner shall attend the case if committed for trial on each day when the same is posted, and default on 2 consecutive occasions may invite the rejection of the order of bail granted to the petitioner without any reference to this court. The application is the same.
May can indulge his lordship, the prior, item number 30 is CJ Kuchbihar lordship. Instead of CJ Jalpaiguri. Lordship, the item number 30 is CJ Kuchbihar instead of Jalpaiguri.
What we have done?
Lordship,
We have granted bail or not? What?
Fixed and witness.
So CGM Kuchbihar and what?
It was Jalpaiguri.
What is this item number 32?
Lordship, the Honorable Court granted anticipated bail to the petitioner on 15 June 2023.
Page
Page number 8.
8.
There is the condition to meet.
Just 1 minute. Same language is used. Charge sheet complete, charge sheet filed? Filed? Yes.
My lordship, charge sheet filed.
Same language by the same bench. Questioning to the investigating officer, what more? The same order.
Lordship 33, I'm appealing for the petitioner lordship. Lordship, the accused petitioner is a lady suffering from various ailments, lordship.
Just 1 minute.
The condition is there.
Just 1 minute. Now, what is the stage of trial?
Charge sheet has been submitted, lordship.
Yes, my lord. See, charge sheet has been submitted. That is on 20.
Sir, we know, sir. The court, the coordinate bench have already recorded in paragraph 5 that more than 5 years has elapsed since the date of filing of the charge sheet. And then investigation, the custodial, then it says a custodial interrogation is not required. So now what is that? More than 5 means now it is 6 years. Not 6, 4.5 years now. What has happened?
What one the report making
This is really unacceptable to us.
23rd November 2026 for appeal. As per the MOE. She has already been submitted.
No, no, I've seen. The learned judge has recorded that having considered the relevant facts, including the fact of more than 5 years having elapsed from the completion of investigation, we are of the view that the petitioner's custodial interrogation is not required. But the difficulty is that I cannot comprehend or synchronize two observations here. In latter part of paragraph 5, it says that we, however, deem it fit to impose certain condition so that the petitioner makes herself available for trial or any other reason whatsoever and whatever the petitioner is required. And then in paragraph 7 says that comply with the direction shall make herself available before the jurisdictional police station once every month. Why?
She was the chairman of Kujbehar municipality and
Yes.
she misappropriated more than
Funds. Yes.
Lordship, I'm not acquainted with the fact, Lordship. Now I'm retired from my service, Lordship. At that time, I was.
No. Why this condition once in a month? What is the difficulty? Only is to ensure that you do not leave. And you are still available, but definitely we are.
After the order, I am giving the Thana Hazira, Lordship, as per the learned court's order, honorable court's order. Now I am suffering from the various diseases, Lordship. As because that's why I am seeking the relaxation, Lordship.
What are the documents relating to your disease?
Lordship, I have not annexed.
Then will the court go by the ipse dixit of the submission made at the bar without any document?
Crave a leave to file. Lordship.
What leave to file?
moreover, she is a very much influential person.
Yes, because I was
She was
But whatever, if she is an influential person and she has been granted bail, there is no allegation forthcoming from your side that they are intimidating any of the witnesses or such kind. There is no allegation which is forthcoming. So you can't now say that she has been interfering with the trial or intimidating the witnesses, threatening the witnesses. Nothing of that kind has come from your side.
action at the time of hearing of the bail application. That is why that condition.
No, that is, the court was of the view that what is the utility of her being in custody, with the hope that within 1 year the entire trial would commence and complete. That is paragraph 8. And nothing has been done as of now.
One the accommodation seeking the report of from Goa. The stage of trial.
Yeah, tell me tomorrow, which Kujbihar
Which we are
tomorrow? Over the telephone, you just confirm to me.
For the petition amount. My lord, I am for the petition amount. My lord, I am praying for relaxation of the order, page number 7. My lord. That they are the father and the younger brother of the prime accused. Yeah, the prime.
Just wait.
My lord.
Yes. Charge sheet submitted?
No. So far my knowledge goes, I should not submit it, my lord. Number one indulgence. So for the bail order of the. No, wait a minute. for the bail order of the principal accused is concerned, there was
Is there any provision in the code of criminal procedure to review the order?
no, but I'm paying for relaxation.
How, under what? It was only condition was that you will go in a police station, meet the investigating officer once in a week. Where is the difficulty? The charge sheet has not been filed. Charge sheet has not been filed.
Subject to your lordship's correction, from the prime accused who has been arrested and got the bail, he never been asked to meet the IO.
So that is a different. It's up to them that what to do and what not to
So
do.
far the petition number 1 is concerned, that is Qasim Ali. He is an aged person, father of the prime accused.
Yes.
At least maybe modified once in a month, my lord. Once in a month, my lord. Because they are the daily labor.
So once in a week, no difficulty. It is on Sunday when there is no work.
Until and unless they give us some medical.
Why?
Whatever.
Whatever, why you have not completed the investigation?
Prime accused has already been arrested and got the bail.
Why you have not? You are in a better footing because you were granted an anticipatory bail.
Being the father and brother of the prime accused.
Why you have not completed?
But
This is a case of
the same jurisdiction.
15th of July, 2023. More than 90 days, 120 days, even 180 days has expired. What more? How long that will continue? This is an application. This is an application seeking relaxation and on modification of the conditions imposed at the time of granting the anticipatory bail on 3rd August 2023 within bracket CRM 581 of 2020. It is submitted by the counsel for the petitioner that the prime accused, the alleged prime accused, in connection with the alleged offense, was arrested and later on announced on bail without imposing any conditions, stringent conditions, like the one which is imposed in connection with the instant case. It is submitted that the petitioner is a aged person, and therefore the condition of meeting the investigating officer once in a week should be relaxed. No, should be relaxed. Astonishingly, in course of the hearing, it transpires that the investigation has not been completed, and therefore the charge sheet has not been submitted as yet. The case was registered as far back as on 15/7/2023. Yet it is traveling on the peripheral of the investigation, which gives rise to a fair and impartial investigation to be conducted. Be that as it may, the concerned officer will definitely sensitize the investigating officer in this regard. So we are concerned with the relaxation of the condition imposed while granting the anticipatory bail. So we do not find from the application regarding the medical incapacity or the ailment suffered by the petitioner, nor do we find that the moment that the investigation is still continuing, any modification or relaxation should be given. It is immaterial that the other co-accused have been enlarged on bail without putting such condition. So it is the moment the court perceived at the time of granting the anticipatory bail, something which necessitated such conditions to be imposed, unless the purpose of such condition is over and or meted out, the court should not go by the ipse dixit of the orders passed by the coordinate bench or the jurisdictional court in granting bail to the other co-accused. The application is the dismiss, no order is to cause.
I come for the petition.
What is that relax?
Page number 8. The order of
Just one. Charge sheet filed? Charge sheet filed, sir?
to the lack of financial stringency, they are not in position to collect. No, I'm saying, due to financial stringency, I'm not in position to collect the local surety. And for that reason, I'm unable to surrender. And the order was.
Then?
The local surety, if possible, all the family members there. They are the cultivator and daily work basis. So there is not in position to file local surety in that amount.
When there is the registered surety, local? Sure.
Actually, so far the local surety is concerned.
Not on a personal bond or a personal bond of the.
The registered surety they can file.
Local surety has to be.
But they are not in position.
No.
All the family members, there are 5 petitioners, they are not in position to.
It does not talk about the local also. It simply says that he will be released upon furnishing a bond of each of 2 sureties of a like amount. It does not talk about the local. It simply says sureties, 2 sureties. It does not only to the satisfaction of the arresting officer.
No.
That's all. It does not talk about any local. So, no, you have jumbled up with the another. So burdened with so many cases.
No,
so
that is not
that must be a case.
That
No.
is not.
Sorry.
But one indictment, the order was with effect from 4 weeks from the date of passing order. That may be extended.
Yes. It was the 6th December.
Yes, sir.
So nearly 1 month.
1 month. Kindly allow me to surrender within a extended period.
The case is under 307.
307 and 30.
Though the instant application is filed for modification and or relaxation of the conditions imposed while granting the anticipatory bail in the order dated 6/12/2023. But the counsel appearing for the petitioner submits that there was a misinterpretation of the language used in the sit order. As the petitioner was given to understand that he is supposed to furnish 2 sureties who are local. After noticing the language employed in paragraph 5 of the sit order dated 6/12/2023, we do not find any such conditions to have been imposed. The only condition which was imposed that this two sureties of like amount each must be furnished to the satisfaction of the arresting officer. Be that as it may, the counsel for the petitioner prays for extension of time so that he may appear before the jurisdictional court and pray for a regular bail. We further notice that the time limit of 4 weeks was provided in the said order, which in fact has elapsed because of such misinterpretation of the languages used in the said order. In such view of the matter, we extend the time for a period of 2 weeks from date. Stop. With these observations, the application is disposed of now.
My lords, I'm seeking for relaxation of.
Is item number 36.
My lords, I'm for the petitioner. My lords may come to the.
Just 1 minute, let the file come to us. What is, you are seeking a relaxation? Where is the
Relaxation of the
original order?
My lords, at the end of the petition,
Order dated
order dated 25th August 2023.
25th?
August 2023. It's third last page.
Just.
My lords, the country.
Just one.
Try to comments wage. Comments wage.
What is the stage of trial?
My lords, one witness have been examined
Out of?
out of 12. Out of 12. My lords, the petitioner is actually a daily wage laborer. That's why he's finding it difficult to make himself available every weekend before the IO. Because it causes a loss of his revenue that day.
What is the charges against you? 420, 468 and 471.
And also 14A subsection B of the Foreigners Act. Biplab Chaudhary. My lords, it's been the trial has commenced. My lords, he may be asked to attend the trial court that he's anyway complying with. It on.
Where they are residing? Where they are residing now?
Your lordship, Jalpaiguri district. The learned court has given him an option.
How the case is now committed before the Siliguri.
Siliguri court.
Darjeeling. So
My lordship will attend every day of the trial court, and if required, he will once a week will report, once a month maybe. My lords, the trial has commenced. He will appear before the trial court.
Yes, sir.
post document.
My lords, he has a valid passport, Indian passport, my lords. So it is a strange case for that matter, but he'll attend the trial court every day.
But you were traveling to Bangkok via Druk Airways through Bhutan.
My lords, the co-accused has been granted bail as well without any conditions whatsoever.
The passport has been seized.
Yes, sir.
What is the difficulty, madam?
My lords, he resides in Jalpaiguri. He has to attend trial court.
But
He
you
has to
can't,
attend
you can't,
Bagdogra police station.
you
So
can't
my
take
lord-
the jurisdiction without the permission. Have
My
you
lord-
obtained the permission?
My lords, it's in the bail order itself, like Kotwali police station and Bagdogra police station.
Yes.
So there's a sort of confusion over here. But so he has been complying with the conditions of the bail till date. He has been visiting the court officer in charge every week till date. August, the order was passed. And today it's February end, towards the end of February, he has been attending, attending the
So,
trial
so
court as
better, it
well.
is better that we expedite the trial and the trial to complete within a period of 6 months. Don't worry, you have been rigorously, honestly complying the conditions since August 2023. Comply for another 6 months.
My lords, make it once a month, my lords, once
is
a
the
month,
difficulty?
he'll attend trial court as well as once a month before the officer in charge of the police station.
She does not want to go empty-handed.
No, my lords, the financial crunch is the difficulty, my lords, that's all. Like he's a grill worker, that's the so once a month, my lords, at least there will some relief to him because four
It
to
is the
5
once
times
in
a month.
week.
Once in a
Once
week.
in a week.
So he has to attend 4 to 5 times. He has to leave his work and attend the court as well as the police station. So once a month, my lords, that would be very gracious of you, my lords.
That's a once in a fortnight. That's it.
Once, my lords, it's a very, it's a very.
That's a very honest and a generous approach.
My lords,
Modest
once a
approach
month
from
and
the-
he'll attend trial court, my lords, he's anyway, once a month, my lords, kindly, my
What is the difficulty?
My lords, he's financial crunch, my lord, he loses a day's wage.
Madam, on Sundays, there is a holiday. You can go and meet the
As my
officer.
lordship-
It does not say that on which day. It says
As
only
my
once.
lordship
So you
pleases.
can go on a holiday.
As
You
my
can go
lordship
and meet.
pleases.
So where is the difficulty?
As your lordship pleases.
Yes, there is a difficulty.
My
Go
lords,
on Sunday.
the co-accused in this case who was granted bail after him, no conditions have been imposed upon him.
That's all.
That's
It all
all.
depends upon the facts. We don't know what is the conduct attributable. I think what is
Same
the
allegations, my lords.
role attributable to your conduct?
Same allegations.
Same allegation, but there are certain other roles.
Custody, man. my
So
lord.
where is the difficulty?
As my lordship pleases. So.
Yes. The instant application is taken out for relaxation of the conditions imposed while granting a bail on 25th August 2023. Well, the petitioner was directed, the petitioner was directed apart from furnishing a bond of 2 sureties, one would be one of whom must be local. Was prevented from leaving the local limits of the concerned police station during the entire period of trial without obtaining leave from the concerned court. The petitioner was also directed to meet the officer in charge of the Bagdogra police station once every week, or any authorized officer of the without the leave of the officer in charge. He was also directed not to leave the local limits of the Kotwali police station, Jalpaiguri, without the leave of the officer in charge, or any other authorized officer of the Kotwali police station. So it is submitted by the counsel for the petitioner that he has been rigorously following he has been rigorously following the conditions imposed while granting the bail. But being a daily rated worker, he has to lose his earning on a day. He has to lose his earning of 1 day in every week. And therefore, the conditions may be relaxed. The Council for the State submits that there is no allegations forthcoming from the officer that the petitioner has misused or flouted the conditions as of now. Considering the plight of the petitioner, that he is directed to appear before the police station once in a week, and bearing in mind that the petitioner earns his livelihood as a daily laborer, we think that it is a fit case where the conditions may be relaxed and or modified. We are also not unmindful of the fact that the petitioner is facing a trial in relation to an offense not under section 420/468/471 of the Indian Penal Code, but also under section 14 capital A within bracket B of the Foreigners Act. And therefore, we do not think that the conditions so imposed should be relaxed in its entirety. We therefore modify the order to the extent that the petitioner shall meet the officer in charge, or what? Shall meet the officer in charge of the concerned police stations as police stations in terms of the order dated 25/8/2023 once in fortnight. All other conditions in relation to a bail granted on 25/8/2023 is uninterfered with. Disposed of.
One indulgence. One matter I have been appointed by CLNC to file an appeal with your lordship without wakalatnama. Just I have the appointment letter of the learned register. But then the concerned department says to seek leave from your lordship.
What for?
That file the appeal on the basis of the appointment by the learned register. That is first time in mind I have also.
It's not expected.
This is the appointment, my lord. The register was supposed to.
No, that is an appointment, but appointment and authorization to appear is a different one. But you'll have to seek an authorization.
Actually,
Either I do not know. I have not come across with this situation.
But we had mentioned before your lordship one CRAN application which relates to release of an sophisticated arms connected with criminal appeal. Well, the earlier coordinate bench had directed once the CRAN is filed, this case would be given priority in hearing.
We'll consider that. We'll do it tomorrow.
360 in the 2 days list, my lord.
What?
360 2 days list.
What I have done is I instructed, because the other day I went serially where the application for bail and anticipatory bail were there. Then I said on the next day, just reverse. So that the bottom matters, they would be given a precedence so that we can meet the end. Tomorrow we'll again go back from the first. Don't worry in this way.
আচ্ছা দাদা, 500 নম্বর কত লাগলো, কত নেবে? তারপরে ধরবে, লাঞ্চ করে ধরবে তো? হ্যাঁ, এরপরেই নেবে তো? এখন বলবে দুটোর সময় তো, দুটোর সময় বসবে তো?
ওটা তো দেখতে হতো। Count at just a count.
Yes.
হ্যাঁ বলছি।
Yes. What is the matter about?
But which item has been called, Malad?
21-22
Yes, 21-22. Malad, I am for the petitioner. Malad, there are two applications here, Malad. Lordship
Yes.
can hear me, Malad?
Yes,
Lordship
yes.
can hear me?
You are
Sorry,
visually and audible both. Yes.
Malad, this is my first ventures after 40 years to appear for the state. Now, Malad, there are two applications before Lordship. One is for transfer and one is for cancellation of bail. Both
Yes.
have been assigned because transfer is basically a single judge's bench. It has been transferred to your Lordship to be heard analogously.
Yes.
So which matter is with your Lordship? Malad? If your Lordship could tell me, I'll tell your Lordship.
Both the matters are here.
No, which one your Lordship is looking at first?
But the file which I am looking at is CRM.
Cancellation.
Oh, it's a cancellation of bail, my lord. Malad, if
Yes.
your Lordship comes to that cancellation of bail application, Malad, the witnesses, that is the victims,
Yes.
were threatened. And ultimately, my lord, a case under section 195A was started by the police. That they were
Yes.
creating disturbances for the boy. Secondly, my lord, the opposite party number 2, who is the accused in this case, my lord, he is a headmaster of a school. Now, how he has been influencing these persons are the father of victim number 4 and the father of victim number 2. Well, they both have been given contractual work in the school where the opposite party 2 is the headmaster. So as a result, my lord, and the case details record, the call detail records have shown that prior to the date when they were going to give evidence, my lord, there has been communication over the phone with the parents and the children. So, my lord, we don't know what to do with them because the principal is in a position of strength over these girls who used to study in the same school. And there are 4 victims in this case who ultimately 4 of them had to be made hostile without following the compliance of section 33 of the POCSO Act. So, my lord, we have prayed for cancellation and the case diary, my lord, my junior is there, my lord, he'll hand over the case diary to your lordships. Aniruddha Bishyash. Your lordship will see.
Is it a
Yes, my lord.
Mr. Mukherjee, the difficulty is because I find it is a case relating to a POCSO.
Yes.
And once the minor victim is there, I think it should not be made live streamed. One of the embargo is, I think
Absolutely
it
right.
should not be.
Your lordship is absolutely right. It can't be
So-
brought on stream, my lord.
No, it should
So,
not
my
be
lord,
live
then I
streamed.
have to
That is,
come. Then I have to come to Jalpaiguri, my lord.
yes, that would be more convenient because
Well,
in
give me a week's
POCSO,
time then, my lord.
what week's time? Then this is the only week which is available.
Oh. My lord, then I'll ask my Mr. Papuli is also with me. I
Arre.
ask him or it can't be right. Your lordship is right, my lord. It can't be done live. But keeps it on Friday, my lord, please.
Can we not do it? It's not a live streaming. Can we not do it in a more encryption to an encryption basis?
As your lordship pleases, my lord.
No,
I don't know
not
the
camera.
mechanism, my
Audible
lord.
is the name of the victim should not be diverse anywhere. We can't.
Yes, my lord.
Can't be.
Like by Zoom, it's end-to-end.
That is what is end-to-end is encryption we wanted to ensure, not a live streaming in this regard. Is a POCSO? Definitely
Yes.
not. Definitely not.
It can appear on Zoom.
True, my lord. The law is, as what your lordship has said, that's the law. You can't
No,
have it
that is
done.
that is what the apex court has also
Right, my lord. Your lordship
have
is right.
said that
Has
in-
laid down.
what are the
that
cases which
principle.
should be live streamed, what are not, and POCSO is one of them. that it should not be live.
Malad, your lordship suggests something, Malad, so that I can go to Jalpaiguri, or my junior would go to
Then you
Jalpaiguri.
come on Thursday, we can hear out with this matter. You have enough time, 3 days.
Right, Malad. Thursday then, Malad.
Thursday.
Right, Malad. Malad, is the de facto the accused or lawyer has
I
any
think
objections
accused
for
lawyer,
Thursday?
the lawyer for the victim or the accused is here. Yes, he is here. He is here.
So, Malad, Thursday would be okay.
Yes, Thursday, you keep this matter.
Right, Malad.
Ready?
Yes.
Oh, 40 years.
Again, we can create a system to June, maybe June, যদি করা যেতে পারে, সেটা হচ্ছে just end-to-end encryption, আর শুনতে পারে। কিন্তু লিঙ্কটা পাঠাতে গেলে কিন্তু এটা পার্সোনাল লিঙ্ক পাঠাতে হবে। এটা নয় যে হাইকোর্টের ওয়েবসাইটের লিঙ্কটা দিয়ে দিলেন তো যে কোনো লোক জয়েন করে তাতে অসুবিধা হচ্ছে। আমাদের কি জুমে নেওয়া আছে, আমি জানি যে 100 up to 100 people there is no difficulty. 100 জন free of cost ওদের কিন্তু একটা সেশন আছে 40 minutes বা 1 hour পর্যন্ত free of cost they don't charge. কিন্তু যদি এটা বেশি চলে তখন তো তোমাকে এটা লাইসেন্স নিতে হবে। সেই জন্য ওটা তোমাকে নিতে হবে, আদারওয়াইজ তো খুবই অসুবিধা। ভার্চুয়াল মোডে করা যায় না, কখন এনি অফেন্স কনসার্নিং দ্য চিলড্রেন শুড নট। ঠিক আছে, দেখো থার্সডেতে রেখেছি, এমনিতেই ইন দ্য মিন টাইম এটা বার করে রাখো এইসব কেসগুলো যেখান থেকে ভার্চুয়াল করছে, কেন আমরা তো এনকারেজ করছি ভার্চুয়াল করুক, হাইকোর্ট কোনো অসুবিধা নেই। যদি ওটা জুম দিয়ে যদি করা যেতে পারে, তবে টপ টু দ্যাট যদি দরকার হয় একটা লাইসেন্স না হলে টেম্পোরারি লাইসেন্স লাইভ স্ট্রিমিংটা হচ্ছে কিছু কেস কিন্তু লাইভ স্ট্রিম করা যায় না, ওটা বার আছে। POCSO তো প্রথম, তারপর চিলড্রেন রিলেটেড, তারপর পার্সোনাল যদি হয় ম্যাট্রিমোনিয়ালেও যেখানে অবনক্সিয়াস অ্যালিগেশনস সেখানে করা যায়। এখন এন্ড টু এন্ড এনক্রিপশন করতে গেলে তোমার জুন আছে, মাইক্রোসফট টিমস আছে, নিজে ওরা কিন্তু ওরা যেটা আমি জানি যে 40 minutes বা 45 minutes এর জন্য ওটা ফ্রি অফ কস্ট করে। আর এখান থেকে তোমাদের ক্রিয়েট করতে হবে একটা অ্যাকাউন্টটা ক্রিয়েট করতে হবে, কিন্তু যদি বেশি চলে তখন লাইসেন্স দরকার, তাই তো? হ্যাঁ, আর আপ টু 100 ইউ ক্যান জয়েন, ওর বেশি হলে লাইসেন্স ছাড়া হবে না। জেনে রাখুন যদি টেম্পোরারি লাইসেন্স গুলো কি নেওয়া যায়, যদি যেখানে 40 মিনিটের উপরে যদি যায় ফর 1 day, এই ধরনের জিনিসগুলো একটু Yes, call the witness.
My lords, I'm for the My lords, I'm for the petitioner herein at page number 8. The bail order is dated 18th October 2023 at page 8.
Once investigating, to be investigating officer
Once a week and not
and
leave
should
the.
not leave the jurisdiction of the
Yes, my lord.
without the leave of the person.
Yes, my lords. My lords, the charge sheet has been
Has
filed
been
thereafter.
submitted?
Yes, my lords.
The case.
306 IPC.
What?
Lordship, in that case, Lordship, once in a month to meet the investigating officer, Lordship, because the allegations are, Lordship, heinous, Lordship.
My lordship may kindly look at the allegations herein. I have stated in my petition at page number 3.
No, once in a month I can understand.
Lordship.
It's, the condition was within every week she has.
Lordship.
He,
Lordship,
sorry, he has. What is the allegation?
My lords, if I may, my lords, the allegation is that the
Just 1 minute. I'm reading paragraph
Page
2.
three.
Let me replicate. What is the role which he has been found to have played in this? Only thing was he was running.
Lordship.
He was running the show
Lordship.
and I think the victim was, or the dead person deceased was in a great debt.
Lordship. Lordship, the
Great debt. Now he was found. How? What was the cause for death?
my lords, if I may.
What is the outcome? What was
My
the
lord,
cause?
if
Where
I'm-
is the inquest report and where is the postmortem
Lordship,
report?
we do not have the CD, Lordship.
Where is
Now,
the inquest and postmortem report?
Lordship, we have to call for the
My
CD.
lords, if I may, my lords, the victim person had hanged himself to death in a hotel room.
Yes, Lordship.
He was found. Cause of death is strangulation, death by hanging, death
Strangulation.
by hanging,
Strangulation.
death by hanging, my lordship.
But death by hanging.
My lords, the co-accused person was given an anticipatory by the previous honored lordships. My lordship, and all the statements are very vague. There's no direct allegations.
Yes, after charge sheet what remains?
Lordship, but Lordship, once in a week.
My
Once in a
Once
for
in
what
in,
purpose?
Once in a, because Lordship,
No, second
just-
conditions, we think.
Not
we
to
will
leave
not
the
inter- We will not interfere,
Lordship,
that he will not leave the jurisdiction.
my lords,
Except with the leave of the court.
Lordship,
So let him take a leave. If he wants to go out, then take a leave, no difficulty.
Lordship.
my lords, one kind indulgence, my lordship, the jurisdiction is in itself, he's a businessman, your lordship. He has to travel often for that
This
purpose.
business.
No, no, not this hardware business, my lordships.
This is
He's in
what
the
you are
business.
running.
No, no, my lordship, he's in the that's an allegation, my lordship. He's a
Whether
hardware
those-
business.
The CD
He's
is
a-
not here, whether the.
No, no, my lordship, the
whether
statements
chips
are.
were seized or not, everything has to be seen.
No, no, my lordship, the matter has come up before two benches. One, he was in custody, the co-accused has also been granted
No, no, I
anticipated.
understand, you have been granted bail, madam, this is not that you have been kept behind the bar. You have been, now the question is that your
My
your
lordship.
role, there is an apprehension, everything. So definitely we can relax, no difficulty, but you seek permission of the court, no difficulty.
My
You
lordship.
take it,
Lordship,
no difficulty.
grateful. my lordship.
The irony of this branch of law is, and the role of the member of the bar, which I perceive, is very unique. When a court grants bail, putting any stringent conditions, they always bow to the court with a smiling face and a sense of satisfaction which they carry after leaving the room. But immediately within 1 month, they come with the application for relaxation.
My lordship, your in charge sheet has been filed, so. Charge sheet has been filed.
Very stringent. This is an application for relaxation of the conditions imposed while granting bail to the petitioner on 18th October 2020. Apart from punishing a bond with two sureties, further, a condition was imposed that the petitioner would meet the investigating officer once in a week and shall cooperate and shall not leave the jurisdiction of the local police station without the leave of the person. In the instant application, it is stated that the petitioner has never misused the liberty granted to him, nor violated any of the conditions so imposed. It is further stated that the investigating officer has completed the investigation and submitted the charge sheet before the court. And therefore, such conditions should be relaxed. The counsel for the state submits that there is no document forthcoming from the side of the police administration that the petitioner has misused such liberty or violated any of the conditions imposed therein. However, he submits that considering the gravity of the offense, the relaxation to the aforesaid condition is unwarranted. We have perused the content. We have perused the facts leading to the LS commission of an offense and the role attributed to the conduct of the petitioner. It is no doubt true that despite in custody for nearly 27 days, the earlier coordinate bench was satisfied that the petitioner is entitled to be released on bail and in fact granted such bail. Since the charge sheet has already been submitted, there is no necessity of meeting the investigating officer as his role in the instant matter has become minimal. after the order Jalpaiguri. Please stop. We therefore, we modified we therefore relax the condition so far as it relates to meeting the investigating officer once a week is concerned. With the rider that the petitioner would attend the case or on each day of trial is commenced. As the default, as two consecutive default may expose himself liable, may expose himself liable to take away the liberty granted to him by way of a bail by the concerned court. So far as the other condition relating to remaining within the jurisdiction of the local police station is concerned, the coordinate bench, the other coordinate bench has taken care of and mitigating situations by providing a leave to the petitioner to apply before the concerned court in this regard. We thus do not find that such conditions is required to be relaxed at this stage. The application is thus disposed of, no otherwise.
Lordship, Honorable Court granted bail to the petitioner, page number 8.
NDPS case granted bail.
430. Order dated 1st
Even
September
438.
439.
439. I was more surprised with 438.
Page number 8. Order date 1st September 2023.
Oh, it's a case of an intermediate quantity,
Yes, ma'am.
not a commercial quantity. No. So what relaxation? You wanted this condition that you will not tamper with the witness or intimidate the witness to be relaxed so that you can tamper and intimidate the witness. What?
Lordship, petitioner resident in Siliguri, but Thana Hazira with Kalimpong PS.
So if you have committed an offense, allegedly committed an offense there, then what? Why you went to Kalimpong? Why you went to Kalimpong?
Once in a week, the condition, once in a month, once in a month.
Why not every day?
My lord,
Charge sheet submit.
charge sheet-
Charge sheet submitted.
charge sheet submitted. 31st March 2023, charge sheet submitted.
Charges framed.
Charges framed, trial is going on.
How many witnesses?
My lord, that I have to ascertain, my lord.
Fortnight.
Grateful, my lord.
This is an application for seeking relaxation of the conditions imposed while granting the bail on 1st September 2020. So the earlier coordinate bench granted bail on publishing a bond with two series. Together with the petition, further condition that the petitioner would meet the officer in charge of a Kalimpong police station once a week and shall attend all hearing before the learned judge
special court, civil court, NDPS, coming from until further. It is submitted, it is stated in the instrument petition that the petitioner is rigorously following the conditions imposed in the said order and have not misused the same. Even the counsel for the state could not apprise the court, is fair in the submission that nothing reported to him by the police officer that the petitioner has violated any of such conditions imposed while granting the bail. It appears in, it is revealed in course of the hearing that the charge sheet has already been submitted way back in the month of
31st March 2023.
in the month of March 2023. And the trial has also been set in motion. In such view of the matter, we do not think that the stringent condition of meeting the officer in charge once in a week is appropriate. And therefore, we will modify the said order to the extent that the petitioner would meet the officer in charge, coming from police station, once in fortnight. Keeping in view that the trial is not unnecessarily delayed. Apart from the same, the other conditions imposed there in the said order remain unaltered.
Grateful.
The application is thus disposed of. It's 39.
I am for the petition.
Where is the order? Dated
Order
21st
September.
September.
Yeah.
Just
Okay,
give us 1 minute. Yes.
But he has to attend the investigating officer at Kolkata.
The commercial quantity.
It's not a commercial quantity. A charge sheet submitted, charge.
Have you seen the today's order of the Supreme Court?
No, yesterday order, I see.
What the court has said in case of a commercial antecedents.
No. Yes,
That was from a Tamil Nadu.
not.
The Supreme Court has been very, very critical on that. That if there is and it is said that so far as a position of the illicit liquor is concerned is different than under this antecedents are there. There are multiple cases against. What to do?
Charge already framed, trial fixed.
It's a commercial intermediate quantity, we can understand. NDPS, we have to be very careful. Earlier case was an intermediate quantity, we have granted a relax the bail. But it is a commercial quantity of 37.
1 minute, if your lordship given 1 minute, But he has to attend the investigating officer from Tinata to Kolkata, NCB officer at Kolkata, my lord. In every week, this is the difficulty, my lord. In a fortnight,
Why you went to Calcutta?
well, NCB office at Kolkata, not in Coach Bihar, my lord. This is the difficulty, my lord.
Recent judgment the Supreme Court has been very critical. Says that you can't grant bail in case of a commercial. Should not grant. So when there is an
This is the case of anticipatory bail, my lord.
he is not found to have possessed. Yet you should. Yesterday or today. I think Justice Vikram Nath and Justice. No, sir.
Judgment regarding
In a case of a commercial quantity, no, sir. 37. Very difficult.
anticipatory, this is the judgment passed by the apex court, anticipatory.
No, it was not. That was the case where the single bench of a not there in the Tamil Nadu that granted a bail.
Anticipatory bail, my lord.
And the matter went. And the
Because
court
this-
says that when there was the state opposes the prayer, today you will find it.
Yes, my lord, I have.
Find it on a live law.
No, my lord, in the copy, I also read out, my lord. This is the grant of. 438, madam. 438 granted by the Madras High Court.
It says that the antecedents of the party, if it is
My lord,
disclosed
I
before
have-
the
I am-
court, how can the court took an exception to section 37?
My lord,
Should not take an exception to section 37.
and I am reading. Fortnight, my lord, once in a fortnight.
No. No. Commercial quantity I have reservation.
As you lost.
Intermediate quantity where rigor of 37 does not apply, I can understand, as we did in the other case. But in a commercial quantity,
Yeah, as you lost. Well, I only want to not place this application for.
no, after you argue, no.
As you lost.
This is an application seeking relaxation. Of the condition imposed while granting bail to the petitioner on 21st September 2021. While granting bail, the court noticed several nexus and or non-observance of the various provisions of the NDPS Act. And arrived at the conclusion that the petitioner should be enlarged on bail. Despite the commercial quantity having recovered from the position of the petitioner. The court was conscious, the earlier coordinate bench was conscious over the gravity of the offense and the possible misuse of the same and impose the condition by directing the petitioner to meet the investigating officer once. Though the state has not come up, though the NCB did not come up with any documents that the petitioner has misused and or flouted the opposite conditions, but the fact remains that the petitioner was found to have been allegedly involved in connection with dealing with in connection with offense relating to an illicit liquor. the antecedents does not instill a confidence in us that the relaxation is warranted despite the fact that the charge sheet submitted has already been submitted. We therefore do not find any ingredients for relaxation of the conditions imposed while granting bail to the petitioner. We have independent discuss. No other. Let's call the next.
Well, at item number 40, well, can it be taken up tomorrow?
No, why?
Well, on behalf of Mr. Mukherjee, has prayed for only not. Well, he's on his legs in court. Well, then can it be passed over? Well,
No, you are competent enough to do it.
well,
Mr. Poddar is here. He appeared in the matter. So he's here.
well, Mr. Mukherjee is on his legs. Well, can it be passed over then or not today?
This is the first time. But this is, I am looking at the order.
Injury is grievous, my lord. Eyewitness is there, 161 of eyewitness.
Well, this is a case where a erstwhile employee was expelled, filed a complaint after 2 weeks. My lord, can the volume, my lord, somebody asked. My lord, may I submit?
Just 1 minute. Let us go through the facts.
If my lord comes to page 16, my
Just
lord, the
1 minute,
incident
1
took
minute,
place.
1 minute, 1 minute. Yes. Yes.
My lord, can my lord's officer be directed to little increase the volume? My lord's voice is,
Yes, yes, yes.
my lord, 23rd of October, I incident a drunken
No, that
ex-employee.
I have read. That I have read that
Fine.
in the ex-employee of your company, you are a team head. You are in charge of that hub office. He entered into in a very inebriated conditions or in a
Condition.
drunken conditions, and then when he was resisted, he started uh, assaulting physically, assaulting everybody, including you. You suffered an injury on your head, neck, mouth, everywhere. That then the guard asked for a help. Sometimes the police came, rescued you from that gentleman, and taken you to a medical immediately for medical examination, and thereafter the entire incident was narrated and a case has been lodged. This is a counter case which is registered after a gap of 12 days
My lord.
by that particular the person against whom you have filed a complaint case,
My lord.
or you have filed a. This is what your case is.
My lord.
So
That is my case.
where is the injury report?
By the brother.
Page, my lord,
Page
28. Previous in these 28.
What about his case? Have you arrested this gentleman who came in the night? There is no reflection. That is what I wanted. What happened to that case where he has lodged an FIR? Have you arrested him? It is a case that the police came and then rescued him from his clutches. What the police did?
He called over telephone to the victim. And when he reached at the place, when he called for, then he assaulted with his other
That
associate.
is what, and his assault, his medical reports are there. What has happened to his? You have taken him to the hospital. Why you have taken him to the hospital?
We are not taking it to the.
You, that is the case. At 1:40 a.m. in the night, in the wee hours. What you did?
Rana called over telephone to the victim.
Page?
Page 2, my lord. The specific
No. Well,
injury report.
injury report, page 29.
28.
29.
Other statement, the record is page 4, 5 to 9. CT scan, X-ray for all is there. CCTV footage has already been collected from the spot.
What the CCTV footage says?
All they together beaten the victim boys mercilessly, and they fled away from the spot. The landlord of the said CCTV owner, he also stated
Where
his
is
statement
where
161
where is that?
Page 16 million. And if your lordship kindly have a look at page 15, the 161 statement of the victim. Sujan Das. Your lordship, the 161 of Vishwajit Mahato is also there at page 40.
Who is he?
He is the friend of Sujan.
No, friend will always talk about his friend's interests.
Kindly
But where is an independent one? I can understand the landlord.
One minute,
It's a landlord, I can understand. Yes.
Before Vishwajit Mahato, Sujoy, Jyotirmay was stating that yes, we have made a plan to retain the.
Oh.
Yes, my lord. That is page
But it is the specific.
40.
What about section 27 of the Evidence Act? Confession made before you, how far? Tell us, under section 27 of the Evidence Act, will it be a reliable piece of an evidence? 27 or 24, whatever. 27, I believe. It says that only to the extent of a recovery or from your statement. Other means other, no. So,
In your statement is there. CCTV footage where.
no, that is different.
The landlord.
That is the different. And he has confessed that yes, we have bitten. And you will rely upon that. What about the complaint which he lost? Has he lost the complaint? The petitioner?
Yes.
What do you have done with the complaint?
If I had page 2, my lord, the complaint has been lodged by the
Petitioner?
petitioner's relative.
That
Yes.
is the complaint which has been treated as FIR.
No, your.
My complaint, my lord, they have done nothing.
That is what I am asking. He is avoiding the answer to what can be done.
They have only registered a GD and they have done nothing. My injury report is there, my lord, they have done nothing.
Yes.
As per the city, there is no.
And it was, but the incident is of 23rd of October and the my complaint is on the 24th
Yes.
morning.
Yes.
Now they came with the new case.
What new case? It's all related with the same incident.
That they pretend they only they for their safeguard they filed.
No, it was, that's why I am asking which one is earlier.
He shifted to the hospital and.
I am asking which one is the earlier one.
That's why the
The petitioner's complaint is the earlier one, or they have said 12 days delay,
obviously they
13 days delay.
yes, treatment was going on. He was admitted with earlier.
Yes.
Can you see the endorsement receipt?
Yes,
Thereafter they lost this.
that's all. You have fractured his nose, you have ruptured all the muscles. And in your case, it is only a tetanus, Tetvac injection is input and then you are released.
Now, my lord, may I submit? My lord,
I have seen your page 17, which you have said.
my lord, the
Come.
CCTV footage was seized by the
Yes,
police.
the CCTV footage will be taken care of. The landlord has already indicated that what he transpired from the CCTV footage.
The CCTV, my lord, if my lord, from the
It will
CCTV.
be, don't worry, don't worry. You stick, yes, stick that statement. Don't worry. Take it. Take it. 164 also, he will stand by your side, no difficulty. But till now, nothing remain. He will take care of your submission. 164, they will also take. Don't worry. Come. Sorry, nothing. Whatever. No. At the first blast, it appears that the instant FIR has been launched as a counter blast to the complaint filed by the petitioner. But after perusing the I think my English is very bad. I think I am the worst so far as the English language is concerned. What I have dictated, please read loudly to him.
The first class, it appears that the instant FIR has been lost as a counterblast to the complaint filed by the petitioner.
What does it mean? As an Englishman, what should I? That this case appears to be a counterblast to your complaint. So, and you interrupted, comma. But after perusing the flow of thoughts gets disrupted. Get it off. This is an application at the behest of the petitioner seeking an immunity from arrest pending the investigation. Stop. It is vehemently submitted by the counsel for the petitioner that the instant case has been launched as a counterblast to the complaint filed by the petitioner, and the police is taking all possible steps to apprehend the petitioner, despite the fact that no action has been taken on the basis of the complaint filed by the petitioner, much prior to the lodging of an FIR in connection with the instant case. Even on the last occasion when this matter was moved, the division bench recorded that there is a delay of 13 days in lodging an FIR. And adjourned the application, adjourned the hearing of the application, as the state did not possess the case diary on the said date. Today, the petitioner contends that the delay in lodging an FIR, having not explained, gives rise to a reasonable doubt over the complicity of the petitioner in commission of such offense. Stop. The incident is vividly recorded in the FIR, and we do not find any dissent on the place or the occurrence of the incident. However, both the parties are not ad idem on their role. First off, according to the petitioner, the de facto complainant in the instant case, in fact, assaulted the petitioner at the hub office for no reasons and rhymes, except that he was an ex-employee. On the other hand, the de facto complainant of the present case indicates that, stated that he was brutally assaulted, which and suffered a grievous injury. At the first glance, we were of the impression that it is a case and a counter case against the parties, but upon perusal of the materials, including the medical examination report, as well as the evidence of the landlord of the said premises, who is stated to have possessed the who has stated to have installed and possessed the CCTV at the site. We do not find that it is a fit case where the custodial interrogation of the petitioner is unwarranted. We thus reject the application for anticipatory bail at this stage.
May I only submit one thing? My lord has passed the order, my lord. May I submit only one thing?
Yes.
My lord, if my lord comes to the report which was called for by the police at page 19 from the Flipkart, my lord, the report of the CCTV at page 19, paragraph 2. If my lord kindly peruse that once.
Furthermore, the investigation is still on.
Yes. Others have to be absconding.
And the others have no, it is still on and at the nebulous stage, which does not instill a confidence on us that the petitioner is entitled to be released, entitled to get an immunity from an arrest. Yes, next.
My lord, I was only paying, my lord, only peruse one paragraph.
My lord, I'm for the petition.
Next.
My lord, 41, my lord, I'm for the petition. My lord, allegation under section 363, 365. For only a minute, my lord, may I only place the backdrop of the case? My lord, the mother
Just
of
1
the
minute.
victim.
Sir, this is the irony of the virtual hearing. Sir, we are perusing the cost papers. The file has been sent to us. Have patience for 2 minutes. Let us see. I will invite you. I will definitely hear you, give you a fullest opportunity of hearing. Don't worry. Just have patience for 30 seconds.
My lord, I am apologizing.
Yes, just wait, because I was just perusing the earlier order of 30th of January. Yes, you were directed to give a report. Where is the whereabouts of the victim? And to place the same. It's a
2021, my lord. One missing daddy has been brought by the mother of the victim man.
victim?
Victim man.
Man.
Yes.
Achha.
And my lord,
Not a boy. No.
And thereafter, my lord, investigation has been started, and there is no whereabout by the investigation agency for the victim. And thereafter, my lord, and subsequently, my lord, on 2023, or another complaint has been lodged, a lady himself declaring is a wife of the present victim, my lord. And my lord, there is a separate case. This has been
No,
started
what?
for the-
Claiming herself as a wife for
Wife.
what? What she says?
She says the missing person is
Okay.
a husband of.
So,
and
so,
they are-
so,
they are
two,
running
two,
from
two
the
missing diaries were lost, one from the
Mother of-
mother and another from a so-called wife.
So-called wife.
Yes, then,
And on the mother, which on 2021, mother has been lodged against the one Chandon, the present petitioner.
yes.
And daughter-in-law.
My lord, may I only interject, my lord? Something, whatever my learned friend is stating, my lord, that is not the current state of affair, my lord. My lord,
No, no, just
that is-
1 minute, just,
My lord,
what
my
is the report? I just wanted, where is the report?
Two report is there, my lord.
After this order of 30th of January? Yes.
My lord, report 81, page 81. Is the report?
Page 81?
Page 81.
No, no, report filed here.
Here's the report.
No, the report must have been here.
Page 81.
Yes.
Nothing.
The part of case study, my lord.
I am asking Mr. PP, on 30th of January, this court directed you to submit a report. That a report is required to be called from the concerned IO as to whether the alleged victim of the alleged incident has already been recovered or not.
Yes, my lord. This is the report.
So, but have you filed the report here? So why you must have kept in your diary? That does not mean that the report is filed in the court.
Report from NDPS police station.
Page?
Page 81, my lord.
This report has no value at all. Because he says with due respect and humble submission in compliance of the learned court's order dated 17/8/23. I am talking about the report after 30th of January 2024. Give me a report. You have not seen the order, eta dekhi do.
But
Show him that order on 30th January.
where do we go to the report? Is there another? 12 to.
Thereafter, my lord, kindly, my lord, page 92, my lord. This is the second affair. And thereafter, the concerned PS, the second affair, Murshidabat, they are also.
We are not concerned with anything else. We are concerned with the recovery of a particular person who have been stated to be missing, either by a mother or by a so-called wife or by a friend or anybody. We wanted that where is that gentleman? We wanted him. You should. We can use our power of habeas corpus as well, and we can direct you to.
But after lodging the second FIR, my lord.
Who lost the second FIR? Whatever is not a case, sir. This is a case where a person is found missing. Now, whether somebody else complains is immaterial. That is their internal problem, whether she is a legally wedded wife or not a legally wedded wife, have a subsisting marriage or not a subsisting marriage. We are least bothered about it. We are more concerned whether you can trace out that gentleman and you can find out. You have initiated a case against this. On what basis? On what basis you have?
Instead of second FIR, my lord, police has been investigated the matter. Also visited the place where they.
Nothing of that kind. That's why the court recorded. Victim has married for the second time. We don't know.
90 appreciate once, my lord. Page 111, my lord. The second report, 111, my lord.
Yes. No, definitely. What is the role of this gentleman?
Yes, my lord.
You are robbing.
Yes.
What is the role of this gentleman? Why you have robbed him?
Yes, my lord.
Investigation is going on, my lord. Police is
He
very
will go and cooperate with you. There is no question of custodial interrogation. You could not trace out a gentleman. You don't know that what has happened. Whether he's alive or he's dead, whatever, you do not know.
That's why he is alive.
Where? Then how you have?
Page 111, page 111.
Oh, I didn't notice.
This is another. Police visited
Just
the
one.
place where they running their conjugal life.
Yeah.
And stayed at a rented house. And thereafter lodging this diary, my lord, that lady also, there is no trace out. The defective complaint on this case. And mobile also switched off.
Where you have found him? You have not. You simply say somebody said that he is living with another person. Is there? He has rented out a flat, but you went. You did not find him there. So, it's still untraceable. What is his role?
My lord, only one line that he came to see me. He told his mother that I'm going to his house. That's the FIR, man. Now thereafter, my lord, he again marries. And again he goes missing.
Though the report is not formally filed by the investigating officer in terms of the order dated 30th January 2024. But the learned PP appearing for the state submits that in fact the report has been submitted, which would find place in the case diary. The case diary is handed over to you, handed over to us. And we peruse the report submitted by the investigating officer. The case relates to a missing of a person, which is still untraced. The mother of the said person lodged an FIR that his son is missing. And thereafter, one lady claiming herself to be the wife of the said missing person lodged an FIR in the same line and fashion. Apart from the fact that the petitioner was shown to have met the person while he was in the house, we do not find any other allegations from the aforesaid complaint. Still, the person is not traceable, and the report revealed that somebody has seen him living at a place, but the police could not find him physically present. Since the investigation is still in progress, and we feel that it is an ardent duty of the police administration to find out a person, we do not think that there is any incriminating materials found against the petitioner for which the custodial interrogation is inevitable. In such view of the matter, the event of an arrest, 5,002 securities, 1 local, with condition that you will meet the investigating officer as and when requisitioned by him, and other conditions of 438(2).
My lord, highly obliged, my lord.
Let's call the next.
My lord, I'm for the petition.
You have jumped 2 circuits, sir. This is the 3rd circuit.
Well,
So I expect that you will do the case.
yes, my lord.
Yes, please. NDPS.
My lord, the jump was not for due to my fault, my lord. The CD was not. First occasion, my lord, CD was not.
So neutrality can be seen. Neutrality, both. Yes.
My lord, the allegation is.
What was recovered from you, sir?
My
I
lord,
think allegedly recovered.
Not recovered from me.
Not.
It was recovered from my father's house, my lord, the principal accused, Amjad Mia.
Yes.
The
You were residing there, or are you not residing with your father?
Not residing with my father.
You have deserted your father, or your father has
My lord, we have
deserted
a
you?
separate house, my lord. My
Yes.
father lives in his house, and my house is at a distance of 10 to 12 kilometers from his house.
Okay.
Now, my lord, the contraband.
What is this word due to oddity of time? I do not know this word oddity.
My lord, that is that will find in their serial list, my lord. seizure come, search come seizure list, annexer P2.
Anyhow, yes.
They have used that word.
So
That's
what
why-
was recovered?
My
What
lord,
was
it
found?
was recovered, my lord, 100 bottles of fencidil,
Eh?
235 gram of yaba tablets, one country-made pistol,
Pistol.
and two brass metal ammunition, Indian currency of rupees 43,000 lakhs 76,000. These were recovered from the house of
43 lakhs.
And another
Bangladeshi? Oh, sir.
that is not reflected here, my lord, in the FIR.
He will say, yes.
So these were recovered from the house of Amjad Mia, father of the petitioner, my lord. Now, at the time
What
of
is the place of occurrence?
my lord, place of occurrence is, my lord will find from
Kuch
name
Bihar.
of arrest, my lord,
Kuch Bihar.
P3, my lord, annexer P3, kindly.
Yes, yes. The post Chamta, PS Sitai, Kuch Bihar.
From the house premises of Amjad Hussain Mia,
Aha, Kuch Bihar.
West Chamta, post Chamta, Kuch Bihar.
Correct, yes.
Well, in their memorandum of arrest, they have stated that it is the house of Amjad Mia.
Correct.
But there are many contradictions in their story, that sometimes they say it is of Asraful, the petitioner herein, sometimes Amjad Mia. Now, my lord, Amjad Mia was granted bail by the landed court below, trial court below. The order is at, my lord, page 19 of a petition, annexer P5. The ground was, my lord, they have not complied with, there was non-compliance of 41B. There was non-compliance of section 42 of the NDPS Act. There was non-compliance of section 50 of the NDPS Act. On that ground, the bail was granted to the principal accused. Now, my lord, in this order itself, my lord, second para, learned advocate for NCB submitted that he has filed the reply of the BLLRO Sitai dated 27/9/23 on the last date from which it is clear that the
That was an interim bail. This was an interim bail which was granted. What has happened? The final hearing?
Lord, I don't know about him, my lord. Amjad Mia, I don't know.
Your father, you do not know.
My lord, I am in Hyderabad. I am a contract laborer, my lord, and I have been taken to Hyderabad. I am working there in a company. I will show the work order, my lord. From there, my lord, my name will transfer. Now, my lord, regarding the house premises, which they claim that it is mine, the report of BLRO have been accepted by trial court, wherein they have stated that this house belongs to Amjad Mia. And the possession was from the house of Amjad Mia. Recovery was from the house of Amjad Mia. Where from my name transfer from statement recorded under section 67 of the NDPS Act, which is not admissible as per Apex Code order of Tufan Singh, my lord. My lord, my lord. So, my lord, these are the facts. Now, my lord, kindly, whether I was present during that period or not.
Any CDR?
These are the, my lord, certificate issued by Chamta Gram Panchayat regarding my residence and my father's residence. This is the work order, my lord. I was from 28th of July 2023 to 25th of August, January 2024.
I was at the site of Hyderabad, concerned one construction company. It's the original thing. In the list of workers, my lord filed serial number 33, Asrafullah.
Yes. What?
My lord, so my lord knows that section, any statement cannot be, is not admissible before the court of law given under section 67 of NDPS Act. And my name transfer only from the statement of my father. And that too, it was taken with, in the absence of any independent witness, as my lord has already seen that they have stated in their FIR, due to audacity of time, they could not find any independent witnesses. But in the other portion of their FIR, memo of arrest and everything, they have stated that there were two independent witnesses present. I don't know which is right and which is wrong, my lord. Now, my lord, poison. There has to be a simple poison of that seeing the raiding team, he has fled away. Or anything of that kind. But he was not present. They have declared in their own.
What about Nawaz Khan's judgment?
My lord, in
The
Nawaz Khan's
example you
judgment,
are
fact was
giving,
different.
the example which you are giving, that is relating to NCB.
My lord, the facts are different.
What facts are different? You said that only thing is the position is a very important factor. There was no position. I can understand that he was there at the time of raid, he fled away and all everything. But Nawaz Khan did not talk about that. It talks about something more.
My lord, there has to be some material which proves that it belongs to me or I have 1% of involvement. It has to be proved. There is not a single document, not any antecedent that I have some criminal antecedent, past antecedent for which I may be implicated. That is not the case. In their entire story, they have not stated that I have any antecedent. They have made a separate case, another case, which is under Arms Act, my lord, which the arms was not recovered from me. It was from the house of the, nothing, my lord, nothing in the FIR or anything which
Where
not
is the
find.
deed? Where is the deed relating to your own property? Where
My
you
lord,
are
then I kindly allow me opportunity, I will place it.
and we have to believe this panchayat certificate.
My lord.
What is the sanctity of this certificate?
My lord, the BLRO report and the trial court had recorded their
And
submission.
I understand, sir. The BLLRO says that the entry in the record of right stands in the name of your father. That may be a presumptive value of position, but it has got no presumptive value on title. First. Secondly, mere recording the name of the person does not mean that his families are divorced therefrom and his families are not residing along with that.
My lord, kindly see the
Now,
161
the
statement
question
of the.
is, you said that you have a separate house. You have come with this.
My-
Where is your house? You must possess some kind of a document, title document in your support. Where is? You could gather this panchayat, the
I
certificate.
have the.
You could
deed, my
not
lord.
gather a
No, my-
BLLRO certificate for your property.
My lord,
That this is, look, this is the porcha. This is the entry in the record of rights. It stands in my name. I am the owner of this property.
give
This
me
is the
1 day
dark number.
accommodation, my lord, I
This
will
is the
satisfy
dark
this.
number. This is the jail number.
My lord,
This is what is a mauja. Everything you can say. You have not come up.
My lord, the 67 statement under 67.
I understand. I know Tufan Singh's case.
No, my lord. In 67, my lord, the father said himself that he resides in a separate.
Whatever is there.
Then allow
But
me to
let
come
us
up
hear
with
him.
the. My lord, then allow me to come up with the deal.
Let us hear him first. What he
Deed, my lord.
says. What he says.
My lord.
Lordship,
How you have implicated
my
him.
lord, my lord, the first thing that I would like to draw your lordship's attention to is the proposition that my learned friend is enunciating, that statements made under section 67 cannot be looked into for bail. That is not correct.
No.
Khaliluddin's judgment is there.
No, even Nawaz Khan has said so. There is no
Lordship,
debate. The
this
Tufan Singh's
person,
judgment was
the
considered.
petitioner before my lords is an international drug dealer. He lives in that house. Even the document that my learned friend wants to, your lordship, to take account notice of, the BLO certificate, my lord. Even that certificate goes against him. It says the person at Amjad Hussain's son of late Dharaya Miya has a Pakka house in plot number so and so, and Astor is residing with his father at the same house. So BLO has said that his certificate says that he is residing with his father.
Oh, BLO is certain matter.
So why is he relying on it?
The court has relied.
What is the link you
My
have
lord,
established?
he-
It's a still investigation is going on.
Yes, my lord.
What is the link?
Link, my lord, he is the person who used to bring these Yava tablets and fentanyl from different persons in the locality and used to sell it in even to Bangladesh.
Any evidence in that regard?
We'll bring it, don't worry. The charge
And what is the date of the incident?
The date of incident 20th of August 2023, and arrest was made on 21st of August 2023 after 30 hours. That is also recorded in the.
Who is arrested? Is he arrested?
This is the anticipatory
Yes,
bail.
my lord. He is absconding.
No, the bail granted
Please
to the principal accused, my lord.
Yes.
We'll fly you back to Kumbia.
Yes.
My lord, he is absconding. Is a more than commercial quantity of Yava tablets, fentanyl, Arms Act is there, like huge amount of cash, 43 lakhs from a daily wage laborer. That to adding that to
What
my
your
lord,
father does?
My lord, he is a farmer.
How many land you have?
Many lands he.
Under the West Bengal Land Reforms Act, there is a ceiling. So how
He
much?
has land,
How
my
much?
lord, that he can say, my lord. Then I have to take instruction that what my father has and what. Even if, my lord, I cannot say as an advocate what property my father has, because he has never disclosed it to me. My lord, the basic thing is that let them come up with any document which implicate my name. Just verbally misleading the court is not accepted, my lord.
who is misleading the court? Farmer getting 43 lakhs.
Any document, my lord, any document.
I want to become.
What he said that I'm international peddler, let him prove it.
We will prove it, Mr.
That I've been wanted by Interpol.
Don't worry. Why are you hurrying?
No, you prove it now.
Why? In the interim stage.
Yes, you don't have any document. I would request my lords to produce the CD whether any implicating
He was given thrice
or incriminating material has been found against me. Kindly produce the CD and ask my learned friend to show any document what he submitted that I am an international peddler. There must be something they found during investigation. Let them.
Why was he carrying an international SIM?
Did you get the SIM from my possession after arresting me? It was kept at my father's house. Where are the call details?
Everything will back.
Where are the CDR?
Why you are keeping silence? Why you have not taken steps against this order?
Which order?
Well,
We are
tell-
challenging. That interim order, Lordship.
Yes, I'm worried about it.
My lord, that is a very.
Kindly ask them to present whether they have challenged or not, any document.
My lord, why is interjecting unnecessarily?
My lord, the recent fact is the NCV asked him not to visit, no more, he is not required to visit as per the direction of the court. Call for a report from the court below, my lord. Or kindly give me 1 day of accommodation, I will bring the deed, my lord.
What?
About my separate, both the deed, my lord, of my father and
How
mine.
can you get a father's deed? You said that you do not know what your father have, and you will get
My
a
lord.
father's deed.
I can manage it.
Then you can manage you
My
yourself
father is
said.
not behind the bar, my lord, he is outside. And if
You said, sir.
but
just
I
because
will request him to give
that-
the,
That
From
you
Hyderabad.
personally speaking, as a lawyer, I do not.
I don't know,
what
but
my
if
father's
I-
property is.
yes, my lord, if I
Then
ask
you
my
say-
father, I request my father, maybe he can,
Request
me.
from Hyderabad.
You are in Hyderabad.
he is in Hyderabad, my lord. I am not in Hyderabad.
Who is not in Hyderabad? Your petitioner is in Hyderabad.
Yes,
And
I'm
he will
telling-
send a request in Kuch Bihar.
So
My
he's
God.
talking about himself.
I'm talking about myself.
So I can't make any comment on it.
My lord, kindly grant me 1 day accommodation. I will satisfy that my house is different, my lord. 1 day accommodation. And also I pray for report from the trial court, whether they have made any application for cancellation of bail or not. Kindly, my lord.
I don't know since when we are supposed to.
I can
file
prove, my lord, their
application
submission
according-
is misleading. Kindly, my lord, allow me.
No, am I
1
supposed
day.
to go by your tune? In which court I will file a cancellation application?
Give the number.
No, are you my moral guardian?
No, you give the number.
Stay within your
You
limits,
are
Mr. Kumar.
misleading the court. Give the number then.
Do you think the court is misled?
My lord, when he
You
is
think so?
submitting, he has to give some base on that, he said he has taken step. My lord, he has stated that he has taken step.
No, you have not heard him. That is the problem. He says we are contemplating to challenge. He did not say that he has.
After
challenged.
so many months.
That is a different issue. That's a
I
different
don't
issue.
think he is
I
my
just
guardian
asked the
angel.
question, have you taken any steps against that? He says I'm contemplating or going. So we have to take it. That's all. He did that till date he has not. That's all. Matter ends.
The petitioner herein has approached this court under for anticipatory bail under section 438 of the Criminal Procedure Code. Full stop. The learned counsel, appearing on behalf of the petitioner, submits that at the time of recovery of the substance from the father of the petitioner, from the father of the instant petitioner, this petitioner, being the son, was not present within the vicinity.
Lordship, just one mention, may I? He has also filed one CRR against NCB that is pending before the single bench. I do not know what is it.
CRR for transfer.
No, my lord. CRR, I have filed for passing of the warrant. Before charge sheet, they have obtained warrant from the court below on fabricated grounds, my lord. That I have challenged before the
Everything
single
is
bench, my
fabricated. Whatever he says is.
No, that he has a right. He has a right to move it. Only thing is whether the court will allow such prayer or not is a different.
No, my lord, he has a right to move it. What I said
No
was,
difficulty.
what he
Yes.
says is sacrosanct, whatever I say is baseless.
No, that.
Unfortunate me.
Appearing on behalf of the petitioner submits that at the time of recovery of the substance from the father of the petitioner, this petitioner being this one, was not present within the vicinity.
Within the vicinity of the place of seizure. Full stop. He further submits that the place of seizure is the house belonging to the father of the petitioner, and this petitioner resides at a distance of about 10 to 12 kilometers away from the house, away from the place of seizure. Full stop. Banking upon the aforesaid facts and circumstances, the learned counsel has sought for anticipatory bail. Full stop. The learned counsel, appearing on behalf of the NCB, vehemently opposes the prayer for anticipatory bail and stresses upon the point and brings to the notice of this court the substances seized, which includes foreign currency or foreign
Foreign SIM card.
Indian currency worth rupees 43 lakhs and a foreign SIM card
My lord, and arms, country-made arms.
and country-made
Lordship,
arm
100 bottles of penicillin,
along with 100 bottles of fentanyl,
235 grams of yaba tablet.
each containing 100 milliliters and 235 grams of yaba tablets containing methamphetamine. ওই যে আর্মটা ওখানে লিখে রাখবেন হচ্ছে কান্ট্রি মেড পিস্টল, আর্ম না বলে কান্ট্রি মেড পিস্টল. The learned counsel further submits that this
Lordship, the
instant
currency
petitioner
that your lordship wanted to know was 43 lakhs 76,000.
43 lakhs and above.
more than 43 lakhs. Full stop. That this petitioner, including that this petitioner is a part of a racket having influence over the border, considering the seriousness, he stresses upon rejecting the prayer for bail. Full stop. Paragraph. Consider the submission of the learned counsel of both sides, and on perusal of the case diary, including the seized substances, list of seized substances, this court, considering the gravity and the nature of the offense, is not inclined to grant anticipatory bail.
Subject, one small indulgence, my lord. Kindly make it not at this stage, because charge sheet has not been submitted.
Then on the change of circumstance, you can pray for that.
Yes, my lord, but liberty.
No
Kindly.
liberty is required, my lord.
At this stage,
at
my
this
lord, if
stage.
my lord mentions, then please. Only 2 word, my lord, at this stage,
Added.
my lord.
Grateful, my lord.
Series the last occasion of sealing of province. We have taken 9. Just see. No. All other coexisting liberty of anticipatory bail, madam.
What series got this?
Why?
Earlier it was fixed on 9th occasion and the city was written just
But it was lastly on 21st, 29th. You asked for a time.
Yes,
Why not? Do it here. Do the case.
Can I see the order sheet? One day. Husband, all legal are granted and continued bail by the Honorable High Court. I.
Produce the CD tomorrow. No day, tomorrow. No. Tell over the telephone to immediately. It's a 1 hour journey.
2.5 an hour.
Then come on Thursday.
Lord, I am for the petition.
Already granted. All have been granted. CD.
Hello. And I am
Yes,
for the
what is the case about?
Lord, the case arises out of a Lord political rivalry. Lord, 30 accused persons have been implicated. Out of that,
30.
30.
Okay.
Lord, 7 is before your lordship.
What are the charges?
Lord, charges principally under section 326 and 307 of the IPC. These are the principal sections, Lord. And Lord, there is an interim order subsisting by a coordinate bench in this matter. Lord, 2 co-accused persons have been granted anticipatory bail by this honorable court. Lord, I have annexed
341, 326, 307, 506.
and 120B and 34 of the items. Lord, 2 factions of different political parties, and due to political rivalry, Lord, all of them have been implicated. Lord, 2 co-accused persons have been granted anticipatory bail by the Larnet District Court also, and 7 has been granted bail by the Larnet Trial Court.
And some could not be.
And 7 is before your lordship, Lord. 7.
Some of them could not succeed in getting that.
My lord, there is no rejection.
Rejection in we find Assis Day and others, 258. That is on 13th of June, 2023.
Oh, CD. Lord, Ashish Day is not before your lordship in this application.
No, our record is very sacrosanct.
My lord.
Even you hide, everything will come now.
No, my lord, this petition is.
No, I am talking about Assis Day and others. You said some of them, 7,
Yes.
but I said some of them also could not succeed. That appears that their application for bail was rejected.
The
Yes.
instruction was not with me earlier.
Yes.
My lord, the allegations are mostly omnibus in nature, my lord. My lord, may I, my lord?
मेडिसिन ये तो देखते बच्चे ना हमें कुछ आईवी है ना पीडी से जोड़ रहे नो इंजेक्शन दिए ट्रांसपोर्ट दिए तो ऑनलाइन दिए नो कुछ नहीं this
My lord, this petitioners, my lord, they have been implicated, my lord, due to political rivalry, first of all. My lord, so far as the injury is concerned, my lord, the section 326 and 307, my lord, there is no such injury, my lord, which says that, and moreover, these petitioners were, there is no direct, my lord, evidence with respect to the presence of these petitioners in the said unlawful assembly. My lord, consider.
My lord, first of all, my lord, two victims are there, my lord. One victim, one injury report, page 66, he was admitted to
We have
hospital
seen.
for 4 days. Yes,
and the
head injury is there, my lord.
and what medicine has been given to him
Well, he was admitted 4 days.
and what medicine was given.
Page 12, kindly be seen on page 12.
I have seen that.
The
We
photograph.
were discussing, yes. That why the NS was given and thereafter the PAN 40, why it was given, everything is given. Don't worry.
Ma'am, kindly appreciate the statement of the victim, my lord. Page
Page?
264 and 265.
Correct.
Two statement of the two victims.
Yes.
Name 3 of the petitioners here in Manila. Out of 7 petitioners, 3 names are reflected in the 161 statement of the victim.
Yes.
Serial number 1, 2, and 4 of this petitioner.
Correct. What he and what about the others who have been granted bail? Their name was also disclosed.
That is, yes.
So why they were granted an anticipatory bail? So, according to the learned advocate for the petitioner, the instant case has been launched because of what?
Political rivalry.
Because of political rivalry, implicating implicating nearly 30 persons, out of which several have been granted anticipatory bail as well as the regular bail. The petitioner says that there is no specific role alleged against the petitioner, and the allegation appears to be omnibus. And in fact, the names of some of the writ petitioners do not transpire from the statement of any of the persons.
Only petitioners. My lord. Should I say to
So you are the only petitioner.
No. Lordship has said read petitioners. My lord.
No, read not read. Some of the petitioners. The state opposes the prayer for bail. The state vehemently opposes the prayer for bail. It is arduously submitted by the counsel for the state that there is a grievous injury suffered by the victims, which would be evident from the medical report annexed to the case diary. So it is further submitted that the victims in their statement has disclosed the name of some of the petitioners. And therefore, no immunity should be granted to them, as the case is still at the stage of an investigation. So our attention is drawn to the orders of the coordinate bench in CRM within bracket A 116 of 2023, decided on 25/8/2023. What is the other?
Let CRMA 349 of 2023.
349 of 2023, decided on 13/6/2023.
My lord.
Wherein the co-accused have been granted an anticipatory bail. We have perused the statement of the victim and also the medical report and the treatment given to the aforesaid victim. We find that some of the petitioners stands on the same footing that of the persons who have been granted anticipatory bail, and some stands on a more higher pedestal because their names were not disclosed by any of the witnesses. Stop. We thus find that the petitioners are entitled to get the similar reliefs that of the other co-accused on the ground of parity. So accordingly, same that of Jibes Bissas.
Grateful to Lordship. Great.
My lordship, may I request? Because on the 16th I had come here, my matter was listed before the lordship, that is 214 item number. And I missed the item on that day because my flight was too late. And I'm waiting here in Jalpaiguri for last 2 days. Today I want to argue my matter.
What more? Where is the other side? What matter?
That is 214 item number.
214, where is the other side? Who is appearing?
Lordship, this is a bail application.
What appeal application?
Bail application for CCL.
Well, I have not received this CD, man.
214.
4. Bail application from CCL?
CCL, yes, sir.
Has he attained majority?
No, sir. He will complete his 18 year in April.
Can a bail application lies before the High Court?
My lordship, because I have some reliance because there is a clear instructions regarding the juvenile justice. That is section 12.
Section 12, I am conscious. That's why I'm asking you whether there is any chance of a bail application to be filed before the High Court under section 439 or 438. What?
My lordship, not 439. That is a clerical mistake. There is some other sections.
Can it, without the Juvenile Justice Board being approached, the High Court can be approached? I'm asking.
My lordship, because this
Come tomorrow, argue. It's a very vexed question. Bring the CD.
All right.
Come tomorrow. Let us see. Argue the matter, whether it lies. What is the effect of section 12?
Sure. Sure. Thank you so much.
Yes. Come tomorrow. Let us see. Yes. Yes. এই জুভেনাইল জাস্টিস অ্যাক্টটাকে একটা নিয়ে এসে রেখে দাও তো বই। Yes. What is this?
Plan not present at the present at the place of occurrence or did not mind him after on the statement of forward.
Why it is sometimes registered as CRMA? Why?
Anticipatory.
Oh, anticipatory. NDPS, they do not give
In case of
categorization.
bail, NDPS.
Okay. Yes, how much?
My implication, madam, I have severe
Yes. Did you sell the vehicle? Where is the document of sale and whether you informed the motor vehicle department? Under the Motor Vehicles Act, you are supposed to inform to the motor vehicle department that you have sold. Did you inform?
agreement, I said, madam,
Agreement you said. What is that agreement?
for the Palace area of involvement, there is no criminal incident, I have no way connected with the instant case, madam. Can
Yes.
see the any instant that I implicated, I anyway, connected.
What was recovered from your motorcycle?
Not motorcycle, it's a vehicle, truck.
Oh, acha. Vehicles, truck. Yes. And what was recovered?
Kaja.
Madam,
How much?
What?
What is the quantity?
Lordship, I'm coming. Total lordship. Huge. Huge. Two vehicles, lordship. Two vehicles. One vehicle, from one vehicle, 5 packets. And from the vehicle belonging to the petitioner, it's 7 packets. Now,
Total 7 packets weighing
7 packets, lordship, total is
2414 WB
for 26.675 kilograms.
26.
0.675
So 26 kgs.
kgs from his vehicle.
How much is the commercial quantity? Just above the commercial quantity.
Now the question is, lordship, how his involvement is? Because apparently he was not present and he was not arrested. 2 vehicles, the police got the information, held a raid and detained 2 vehicles. So the driver and helper of both the vehicles were apprehended. The driver made a statement before the police that he is saying that he has sold the vehicle, but the driver names him and states that under his instruction, the articles were carried. It is there in the case diary.
Okay.
And the CDR says between the 2 vehicles, they had communication, continuous communication at the time when the vehicle was apprehended, just prior to this. So it's not that both the vehicles were unknown to each other and were traveling. It's conjunctively, but they were taking those articles.
And what is the date of incident?
Date of incident, lordship, 17/6/2021.
17
6.
2021.
These are between 14:35 to 16:45 hours.
Okay.
As per this is a list.
And what is this? Is a WP is a what is a truck? No, it's a Maruti. Suzuki does not make a truck.
This one is Boleno, another is Boleno, another is Tata Ace. 2 vehicles are there. One Boleno and one Tata Ace.
And both owned by him.
No.
Only then he is.
His one is Boleno and that the truck 2414 is the truck.
What are you talking about? The Maruti does not make truck.
Boleno and another one 2156 is the
Correct. So
Tata Ace.
Maruti Suzuki never makes truck.
No, 2 vehicles.
What is the year of? The manufacture of that Bolano,
Vehicle, lordship, vehicle.
year of manufacturing,
lordship.
chassis number and all
Lordship,
everything.
yes,
that-
yeah, I have also. Okay, since 79. 79, lordship. His name is Mridul Dev.
No, yes, what
Yes,
is
yes.
his
It's a
vehicle?
Saloon, year of manufacture.
No, no, salon, this is,
Salon,
yes,
2006,
2006.
registration date. Here, the
No, I got it.
salon.
Yeah.
So what is it? 2021 is not like 3 years.
Yes. What is where the charge sheet has been filed?
Yes, sir.
Trial has commenced? He is the name accused there.
No, not the English, where is charge sheet?
Charge sheet he has been robbed in. Hmm. Yes.
Charge sheet is named. That's fine, yes. First one is the main one.
Is there any incident against him?
Yes.
Antecedents is nothing?
Okay. But page 191, lordship equalities, page 191. Page 191. Page 191. The person was apprehended, clearly named Z, was taken into remand and during remand, then became zero.
Alamgir has been, where is the Alamgir? Where is an Alamgir has been arrested?
First, fourth person, Kumar Roy, Raidul Mia, Malakar, and Nabu Ho. The driver and helper of both the vehicles, they were afraid. And Chashmi has
হচ্ছে যে ওর কাছ থেকে গাড়ি নিয়ে এসছে কিন্তু Alamgir সবকিছু শুধু বলেছি ওর কাছ থেকে হাফ হাফ এখন কি করছিল বলো? It's a very weak piece of evidence. director volatility, দেখুন আমাকে গাড়ি দিয়েছে, আমি একটা পয়সা নিই। ও নিজেই বলছে, যে আলমগীর নিজের কাছে গাড়ি দিয়েছে। এটা পাচার করার জন্য আলমগীর চাইছে, আর নিজের ওখানে থাকছে, কিন্তু শুধু অপোজিশন আছে, নতুন His role appears to be, I'm very, as you know, I express my mind. What he has said, first thing he has said is that he was carrying it. Then he said there's some Alamgir who actually loaded these. He loaded and supplied everything. This Alamgir took this particular vehicle from him. So it may be that somebody who is a good friend, somebody who is he gives this his car on a rent or for such purposes. These, I'm saying, sometimes it so happened, the friend, he has given it. Only one word which he has said is, because since the charge sheet has already been submitted, no difficulty in divulging that. He has said that he used to get some, the share from there. That's the only thing against him. Only share he used to get. But how much share, in what respect the share, nothing. What interrogation? This is what he can go and cooperate with the investigation. Why custodial? Why custodial? No, we know, but this is the case. It's a very weak piece of an evidence. Only this word, nothing more than that. He never said that he got it this car or the Mridul gave him a car. Mridul loaded those materials, nothing. It says everything is done by Alamgir, who is also absconding. Not arrested. Only thing is he said he used to get share. That's all. What he knew? Nothing.
Getting shared material.
At least custodial interrogation kiya ho. Let him go and face the investigation first.
And if it does not cooperate, then please.
No, always. But if one chance, then he will. But he has to be there. I wanted an antecedent. If there is an antecedent, one case, if it is registered against him, tell us. If any one case, if it is registered against him, tell us. We will not grant straight away.
No one has been mentioned. No one.
In which jurisdiction it is registered?
No. Yes. Every Kotumali.
Jalpaiguri means? I know. I was thinking of putting how much stringent conditions one can put. But that his address is at Alipurdwar.
And in the vehicle, there is an address of Siliguri also. So I don't know where it is. There is a care of address of Siliguri also. The registration certificate.
Where it is?
Page 79. The RC book is a care of address of Siliguri also.
70?
79.
No, this is Alipurdwar, the same address as he has given. Temporary, that is what is given is. Temporary address is of Siliguri, but his permanent address is here.
The permanent resident of Kalchini, that is Alipurdwar, but not temporary residing at Siliguri. So not the direct
You stay within Kotwali? Yes. In your house is within Kotwali?
No. Yes,
That's the stringent condition, he will live there and you ensure that he goes. This is the application. For anticipatory bail at the list of. At the behest of the owner of the vehicle. From which the contraband above the commercial quantity was recovered. Admittedly, the petitioner was not at the spot. When the raiding team intercepted the vehicle. And recovered the contraband within that ganja above the commercial quantity. The driver and the helper of the vehicle was interrogated. And it is a case of the prosecution that the driver divulged the name of the petitioner. That he is the owner of the said vehicle. The reliance is placed upon the statement of the driver who was driving the said vehicle. And on the basis of such disclosure of the name of the petitioner, the petitioner has been declared absconder. The prisoner is declared absconder. He is already declared absconder. Whether he came as declared, otherwise I was really wondering that 438, then it will not.
82 addiction is not normal. It is shown as absconder in the charge. Not proclaimed. Not absconded, not a fair. Not proclaimed. No pass.
That is stuck, that how can he maintain?
But then 82 has.
Reliance is based upon the statement of the driver who was driving safely and on the basis of such disclosure of the name of the petitioner form of petition which is there.
Declared, he is shown absconder in the charge sheet. Admittedly, he has not been declared, proclaimed, and be proclaimed as absconder. Of it, no, he's not been declared as absconder by the concerned court, by an order of the concerned court. But since he was not interrogated, having avoided the arrest, he was shown in such capacity. Admittedly, the contraband above the commercial quantity is not recovered from the position of the petitioner. The driver, in his statement, so revealed the name of the petitioner, but did not appears to have said something more than that, which would involve the direct complicity of the petitioner. It is a matter of trial. Where the involvement of the petitioner is required to be established. Considering the statement of the driver and the fact that there is no other material disclosed as at this stage
we do not think that it is that any custodial integration of the petitioner is required in this regard. We are therefore inclined to grant the petitioner and the immunity from arrest. So, in the event of arrest, 10,000 facilities, one would be of local, subject to the satisfaction of special court, NDPS, Jalpaiguri, and subject to the conditions enshrined under section 438 within bracket 2 of the Code of Criminal Procedure 1960. It is further ordered that the petitioner shall lead the investigating officer. What investigating officer, what the role will do? You have to then further investigation, you have to seek the permission from the.
After introduction, if something is there, we have to.
He is the investigating officer once in a week and shall remain within the territorial jurisdiction of a Kothavali police station within bracket Jalpaiguri, and shall not leave such jurisdiction without a prior permission of the concerned court. Since the petitioner has shown himself the resident of the district of Alipurduar, on the date of on the date when he surrenders before the concerned court, he would disclose the address of the residence where he would be residing within the jurisdiction of within the territorial jurisdiction of a Kothavali police station. And on being satisfied, the court may pass an appropriate order in this regard. Any violation or non-cooperation by the petitioner, either during the further investigation or at the time of trial, it is open to the prosecution to pray for cancellation of the bail without any reference to this. Before your law, these conditions. The conditions which have been given is inflexible and will not give any right to the petitioner to pray for relaxation or the modification thereof.
Before your lordship rises, my lord, item number. My lord. Before your lordship rises, my lord, item number 5, the passed over item bail in connection with appeal. Will it be taken up tomorrow, my lord?
Tomorrow we are taking up.
My lord, then one request, my lord, then to kindly keep it at the top of the list, then it could be because.
Yes.
Huh?